What is up, trial watchers? Hipplers, hip to the hip, to the hip, to the hip. Wow. Let's see. Hey, Miss Potts. What link is he rolling off of today? You know, hippie dick. Hit that thumbs up. Let's do it. Court's website link at top screen hearing. Is this what they're rolling off of? Let's see. You guys have anxiety. I'm running 2 streams at the moment. What up? Welcome. I think is it going to be rolling off of this? Oh. Let me mute my. All right. Again, welcome everybody. Triple duty, man. I'm just all over the place. I'm in beast mode. You have no idea. Let's get fired up. Oh, listening. What do we got? We will see what we got going on here.
Is we make an incision with a scalpel behind the ear from one side to the other. That allows us to reflect or pull back the scalp, and that will expose the skull underneath. We do this carefully so that we don't disfigure.
Okay. Everything sounds good. All checks, microphone check. All right. Is Murky in this one or is she in the other one? Welcome, Christine. Real Tea. Welcome. Is it Emmy? Bob, welcome. New members, shake it. You guys, who is tailgating for the truth? I am sliding. Look at all over the place. Back and forth and back. I have 4 monitors. Let's do this. Bryan Kohberger live in court, Boise, Idaho. I'm here back and forth. Is this the link that you have for it? Because this is the link I have for it. So, and then, I mean, I'm not expecting them for another 8 minutes. So, we'll see. What is up, Bayar Hayes? How you doing? Hopefully you're doing well. It is too early for a Borg. It's never too early for a Borg. Come on in. Everyone says they're so nervous. I don't know what everybody's so nervous about. Don't forget to smash that thumbs. Yeah. Hit the thumbs, spread the love. Be kind in chat, love. Karen Reed case over there, just pure fire, just exposing the corruption. Loving it. Watch this. I'll be on both streams. Well, I have to wait because she's in the middle of her little talks. I'm watching you on both, right? I have all my screens up. Lana, tell me how much sleep do you get each night? I average probably like 4 or 5 hours. I'm good. That's all I need. For right now, at least. Let's see. Yeah, like 2 to 7. 12 or 1 sometimes, it depends. Lana, is it normal for a judge to demand proof of third-party culpability? You have to make a nexus, but just let's say that Ann Taylor comes up with it right before court. I mean, he can say whatever he wants right now about his little deadlines. Clearly, his deadlines don't mean a damn thing. He's not even following his own case management order. So, but Bryan's rights are going to trample over everything. So Ann Taylor's going to be able to present third-party culpability if she can make it even in the trial. Just like the ARCA witnesses were allowed to, present for Karen Reed, even though they want to claim that there's late disclosures or whatever. The defendant's rights are going to trump that. So we'll see. Again, come on in. Welcome. Here we go. Third-party culpability. We are about 5 minutes outside, 5 minutes. There's a couple things that are going to be going on today. It's not just the third-party culpability. There's some outstanding shit. So I'm sure I want to know if we're going to get a little sneak peek at this whole supposed, here we go. Corey's on a short break. Hey guys, what's up? I'm on both streams right now. Look out. We got bingo going on. Karen Reed case. Karen Reed case is on a short break. Morning break. I figured she'd break for me so I can do my Kohberger shit. Bev's been working on my schedule. So welcome. But I want to know if we're going to find out about this little watered down jury instruction. It's sealed right now. I just want to know if there's going to be some talks about it. There shouldn't be an echo. Is there an echo? Oh, hold on. All right. Is there an echo now? I might have. I know. I figured out why there was an echo. Good morning, crime fam. Justice for these littles. Yeah. Justice, truth. Yeah. I had both feeds going. So I got my little cheat sheet out here. What does she need to make any rulings on? Well, I want to know if we're going to talk about Dateline. I want to know if Dateline is going to be brought up. I want to know if this gag order is going to be talked about. Let's be honest. Dateline coming out and saying that their source is law enforcement. I mean, it's pretty wild. Who do we got? So I am ready for third-party culprit. I want to know if Ann Taylor's going to come out and whip out. I wanted to show you guys. Damn. So I was going through all my old school, like all my screenshots. I have a bunch of different devices, like obviously computer, laptop, tablet, phones, and I found on December 20th, 2022, I have proof of it. I was looking into Cole, the kid with the kid that was tested for the fingernails, the DNA on Maddie's fingernails. I looked into his LinkedIn back in December of 2022. Snatched up that screenshot. He was on my list. He was on my list, and he was on other people's lists too, because you can see how much he was Googled, looked into. So I thought that was interesting. I finally found that screenshot. I found a bunch of screenshots. I went back to we got to talk about these Venmos at 3:30. These Venmos at 3:30. I'm going to do another look into these Venmos at 3:30. Paying Venmos and saying that they're for 3:30. Very interesting. Or bad luck. I mean, just wow. So third-party culprits. My bet is on. I mean, if I'm Ann Taylor, you're going to have to include in some type of way Dylan or Bethany. And that they could be, not that they did anything, but that they're covering for what truly went down. Again, that's my opinion. I think that there's a lot of issues with, everything is coming from this whole, what Dylan, Bethany, and the victims were talking about upstairs, why they were up there. Why would they ever consider going back out when Kaylee and Maddie just got home from getting food? If you thought Xana was just on the floor in a pool of blood and she was just, hung over or drunk or whatever, passed out, you're looking up on Snapchat to check their maps to see where they're at. I mean, that leads me to believe that you don't think that they were home, because when you went to bed, they weren't home, that you would be looking up Snapchat maps for Xana and Ethan. So it'd just be really, really interesting. I know if I had that discovery, I'd be able to lay some pipe. You'll do anything but agree with the facts. What facts? What facts? I go straight from the documents. I don't know what facts there are. Oh, what Dateline? The facts are that the prosecution and the state literally helped the police, because they all worked on it together, violate somebody's rights. So I mean, I don't know. That's a fact. But a lot of people out there say that that doesn't. Who cares? Who cares how you got to somebody? And that's just not how the country works. I mean, if you want the country to work that way, then make the changes to make it work that way. So I'm all about innocent until proven guilty, and I go straight from the documents. So, and when people want to come out and speak, I listen to what they're saying and analyze what they say. But to listen to somebody on Dateline tell me what Bryan Kohberger was thinking or what I don't give a fuck about any profiler. I'll profile with the best of them. Let's go. I'll dissect the discovery. I mean, if you're going to sit here and say that the car was such a big part of your investigation, well, then I hope to God you have a lot of information and a lot of reports of you going in and talking to people with a white sedan leading up to finding out Kohberger's name. That's what's going to show you that you have integrity in an investigation, and that's what's going to show a jury that there are a lot of things here. But that's not what it shows. That's not what the affidavit shows at all. The affidavit shows a complete lie. The affidavit shows that you tried to tell the world, and even Ashley Banfield can admit it, because she said, that they knew November 28th, 27th about Bryan Kohberger because of the WSU bullshit they put in the affidavit. That is not how they got to him. They lied. They created probable cause on all lies. So that's what I know. Logic tells me that. I believe that this murder happened. I believe two people at least were involved. So could it be Bryan? Absolutely. His DNA's there, right? Fuck yeah, it could be Bryan. Come on, let's go stream. We got 11:04. Did this thing start? What's going on here? Let's see here. Let's go like this. I think it's great that Karen Reed's on a break when this stuff kicked off. Okay, let's go like this. All right, we got two different things going. We're covered both ways. It hasn't started yet. Hitler doesn't give any warnings. He just fires it off. Oh boy. Oh shit. Again, good morning. Good morning. We are just waiting for the courts to say, doors open. Again, welcome all the new members. If you guys are joining us over here from the Karen Reed case, look out. I wonder if, Britney Spears feels special about Bryan Kohberger listening to Britney Spears. So I went back and checked out too. Remember how we were all looking at, remember Judge Hitler said that Dylan was just like editing pictures and posting online. Do you guys remember the 3:33 a.m. pictures on Visco? I went back and pulled all those out. She was online and she uploaded 3 pictures at 3:33 a.m. So all that stuff that came out back in the day and that was on there and they deleted them. Okay, those were deleted. Okay, yes, those were actually at, because it just depended on whoever took the screenshot, depending on what time zone you were in to know exactly what time that truly was. And 3:33 a.m. 3:33 a.m. is when Dylan Mortensen uploaded the pictures from the Friday night. And I'll show those when I do a live coming up. No. Let's see. If Anne's bringing some heat in here, and she's going to be saying names, Hitler might say, well, do we need to have this as a sealed hearing? It's like, what are you talking about, man? What are you talking about? Well, the world can't hear about these third-party culprits. Are you kidding me? Yeah, we can. Like, that's what happened in the Karen Reed case when they labeled all the Colin and Brian Albert and Higgins and Jen McCabe. I mean, absolutely. And so, Relax Senior, is that you? Is that you, Relax Senior? He's my favorite senior. Where is he? Maybe a girl. I feel like the way that he writes, though, it's a guy. There. Now I'm pretty sure you are cloned. Yeah. Double trouble over here. Double trouble. Yeah. I thought Mr. wants to keep everything open, right? I thought everybody wants everything to be open. Not this, huh? I like that one, the bar. Damn it, I have bingo and nobody is home. I gave you bingo. Murky, give him a bingo. I double checked it. He emailed me. Yuri on the bingo kick. Scratch cards. We'll go with a surround Bev's head bingo for, here we go. Surround. Congrats, Yuri. There you go. Got me working on both computers here. Oh, let's see. Confidential my ass. I think the state's going to get their bell rung a little bit. We'll see. If I was Ann Taylor, I'd be coming with some questions to say, Your Honor, it was funny that I was just sitting at home drinking a glass of wine, and it comes across my TV. Dateline is showing pictures of my clients out of my client's phone. That is, I don't know where they're getting these photos from. What if she was to say, I don't even have these photos? I don't know how material is leaking to Dateline, and they're over here claiming that it's law enforcement. They're saying that they have what law enforcement has. So I don't know. But I'm over here just sipping my wine, and coming across my Dateline, my screen is Dateline. And Keith Morrison talking about footage. How about Keith Morrison go out and get that 330 to 405 Linda Lane dumpster cameras? How about you go and get that one? You guys would be badasses. Go get the Linda Lane 330 to 405 dumpster camera footage. It exists. It was there. And somebody, I don't know, destroyed it. But the FBI never looked at it. Those of you guys that are following this case, I posted it a couple weeks back that Special Agent Balance from the FBI, he's in the Daybell case. He put a motion in, did something, and he is asking to not be able to be seen for his testimony for the Daybell case because he is working an undercover operation and blah, blah, blah. So, Anne, Your Honor, I am at home drinking my wine and working on my case. And to my surprise, yet again, the MSM has evidence in this case that I don't have, right? Think about that. And to my surprise, I was engaged in a sexual act. And to my surprise, I see my client's picture across the screen. Yeah. Oh, court begins soon. Let's do this. Here we go. Uh-oh. Here we go. Oh, full blast. Oh, God. It's on. It's going. We're getting it. It's happening. Court will begin soon. Take that. We need a bell. Woo! Tailgating for the truth. Yeah. Is that right? My phone's blowing up. We've gotten family members hurt on this case. I got people texting me. Hey, I took an early lunch. Is this really happening? Don't know. Yeah. Will you be there? Oh, I'll be there. All right. All the blood, sweat, and tears into this case. Boise, straps. We're coming. Dateline producer admitted they photoshopped photos. Well, I mean, I don't know. All I know is Dylan was posting photos at 3:33 a.m. fact, and saving a contact to her phone at 3:51. And then miraculously, she just falls asleep. Doesn't tell the cops about any of this. I don't know. I don't know why you wouldn't. Maybe the questions didn't ask her. Like, I mean, when she says that she went to bed around 3 or 3:20, I think the question was asked, what time did you go to sleep? What time did you wake up? Yeah, it'll be interesting. She testified at the grand jury. So, you know, in the Karen Reed case, they're using a lot of testimony from the grand jury. And if anything has changed, they're going to know about that. And they're going to go after that. And then whoever testified at the grand jury talking about Bryan Kohberger's vehicle and where it was, and that the phone shut off at 2:47. Ooh, daddy, I'd hate to be that motherfucker. Woo! That phone did not shut off at 2:47. And they knew it. I don't know if I can speculate on who the perpetrators are. Right now I question the time of the crime. That's where you would start. If you're going to be going and talking about third-party culpability, you're going to be talking about the time of the crime, and that it's not the time that is being alleged. That's where you'd have to start. Anne's already hinted at that. Anne's already hinted at that. That if you believe that narrative, I guess. No. So once you move the time of the crime around a little bit, normally if you want to set something up, you're extending somebody's life. So people would have already been dead and you're extending their life. You know, that's what happened in the Brian Drake case. They extended Brian Drake's life. Brian Drake was already dead, already shot. So, and then lo and behold, in that case, right there in Idaho, they had a car circling the same thing that they're saying happened in this case. And, but if you put it all together, the time of the crime was way before that car or truck was circling. So in this case, when they want to talk about that car leaving, that car will have nothing to do with anything if the crime was before any of that. So we'll see. Again, we're just looking for the truth. And the truth comes from the documents, the discovery, the work of the investigators. I mean, they didn't have a clue on who did this, so they should have been out there day one, pounding the pavement to get as much as they could and to preserve as much as they could, because they didn't have a clue. Right? So there should be a lot of stuff. And Bryan Kohberger could be one of the people. Like I said, right now, I'm leaning towards the fact that I think this was done by more than one person. Just like in the Delphi case, I think that was done by more than one person. I was there for the DNA stuff. I was there to see the photos. I listened to the testimony, and how that jury found Richard Allen guilty is absolutely a sin. His DNA wasn't even there. There was other people's DNA, though, that were at the crime scene. And it was stabbing, same type of thing with the Idaho4 case, except it was 2 people instead of 4. It was a stabbing. It was moving people from one location to another location. And you're not going to find any of Richard Allen's DNA at the crime scene. And this jury still found him guilty. Unbelievable. So Karen Reed's case is going on today. I have 2 streams going. I think it's interesting when I want to hear the detectives. I always like to I want to hear what these people have to say for themselves as to why they were able to rule out that it wasn't multiple people. You know, how could that leave your circle of possibilities, and when did it leave your circle of possibilities? Evidence is what would take you away from that. Also, not that their interviews matter in the beginning, but saying that there was stuff at the crime scene that led them to believe what they were believing early on, which was that this was an isolated targeted attack. Isolated targeted attack. Okay. Well, I would think a serial killer or someone who's trying to be a serial killer, that is not an isolated targeted attack. And the time frame that they're trying to say that this happened really is not like that. I mean, if you see a car still on the cameras at 4:07, okay, by the time that he has to then go park this vehicle, get out of this vehicle, go into a house that he does not know. There's no evidence that he had blueprints of this house. Everybody wants to say how wonky and weird it was. For him to go in, go directly upstairs, kill Maddie, and basically, because Kaylee either was in there or came in there, then kills her. And then Xana supposedly then came upstairs while this was happening and then ran downstairs, and then he killed Xana, and then Ethan, and then he got up out of there. All within, we're talking about 4 minutes. Because you have to go by off the thud allegedly, according to their timeline, 4:17, and so you're getting into the house at 4:10, and you're going to believe that this all started at like 4:11, 4:12. So I think of serial killers as more of like a opportunity. And then when you're doing something that quickly, right? It's sloppy, right? And then come to find out that Dateline wants to say that he possibly sat down on a chair in Xana's room, and now there's rumors that Ethan's carvings in his legs or whatever they did to his legs were after he was dead. I mean, that's the shit that's being talked about right now. And I'm over here like, what? Who's putting this out there? Dateline. Dateline's putting it out there. I agree with Andrea Burkhardt as well. There was I think me and Andrea Burkhardt think alike with you. It's not logic. You can't sit here and say that a kid is is a criminal mastermind, and then you just go and do like the most ridiculous shit. I've said it from day one. Why wouldn't he leave his phone at his apartment? It's in the middle of the night. You're supposed to be at home sleeping. No one's going to have an alibi at 3 or 4 o'clock in the morning. Why in the world would you ever bring your phone with you? You would not. Like, never would you bring your phone with you. That's like 101. Like, that's not even like up for debate. If you're planning, and you've been planning this since March or January when you bought your mask of 2022. Sorry. If he also, I mean, there's just like, let's throw this out there. The car goes there at the first time at 3:29. That's at 3:30. That's what all those Venmos were about. 3:30. 3:30. Why couldn't this have started at 3:30? Or like 3:40? Well, because the car leaves. Well, you're an idiot then. Who cares? You can't, two people couldn't have been in that car for somebody to get the fuck up out of the car? That's insanity. That's exactly what it seems like to me. It seems like somebody was dropping somebody off. And they're coming back waiting. It just, why couldn't the first drive by at 3:29, 3:30 be somebody getting out of the car? And then I would think that your the roommates would be super, super important. And so when you downloaded their phones and you got them the first day and you downloaded them and you had your experts go through them, you would have seen right away, if you're really truly doing your job through the extraction, you would have found what Josiah Roloff found. You would have found what Tom Slavinsky found. You would have found this shit. Okay. And now the question is just like they found the shit with Jennifer Drake. They found shit. And then they asked her some questions about it and they let her basically like lie to them and act like she doesn't know what the fuck they're talking about. So that's where I want to know about the questions that happened the day after I know, or the 2 days after I know somebody went through the extractions of Bethany and Dylan. The type of questions that would be asked after looking through their extraction of their cell phone would tell you everything. What are they doing? Court will begin soon. Court will begin soon. What's the problem here? It's 11:29. Hippler starts on time. We know that, so I have no idea what's going on. I don't trust Idaho. I don't trust Idaho State Police. And clearly somebody lied when they wrote up the probable cause affidavit. They had no problem doing it. So how can you trust an investigation when somebody does something like that? How do you trust it? And the answer is like, you don't. It puts doubt in your mind. That's all I'm saying is, wow, why would you have to do that? I'd be fine with you took the swab from the sheath and you put it in databases that you weren't supposed to, and you just admitted that that's what you did. That'd be like, that's what they did with the Golden State Killer. That's what okay, I get it. That's fine. That's not what we have here. This is way beyond that. This is deciding that you're going to do that, then you're not going to use it, and then we're going to lie in a probable cause and make up shit that's not true. Why? So, and then people say it doesn't matter. Who cares? And I'm saying that is what you can think that way. I'm thinking as an American, and no, it matters. It matters. It matters, especially to people like a Sheldon Jeter Jr. Okay? You cannot fucking do this shit. What's going on over here? Karen Reed. Kevin. Yeah, I think our rights matter. That's my take. I think it's also the blood. Okay, guys, let's talk about the blood. The only way that Ann Taylor could get around to be able to say that there's multiple weapons and multiple perpetrators is because of the forensic evidence that is there or that's not there. Okay. The first person that you kill, their blood all over a knife that you say you just used one knife, and then you go and you kill the second person, and then you kill the third person, and then you kill the fourth person. Do you know what type of transfer that there would be from stabbing to stabbing to stabbing to stabbing from the different victims? If that's not, if let's say that Maddie or not Matt, Ethan, Xana, if there's no transfer, that's problematic. If Xana's in a pool of blood, it's her own blood, and the wounds, and they were swabbing, and it's only her DNA. It's only her blood. It's just her blood. There's no mixture. Okay. After Maddie and Kaylee were killed,
State v. Kohberger. Defendant and counsel for both sides previously identified are present. We are in the public session now. I have my own agenda for what to cover today in the pretrial motion, and so I'm not sure what you have. I didn't receive any specific motions to cover today, other than I think the ones previously submitted by defense related to questioning of the jury. As I indicated, I don't intend to discuss in the public forum what specific questions would be asked of potential jurors, because I think that inhibits the ability to get frank and unprepared answers from potential jurors. And so we may have to cover part of that in a session at the end of the day. I think we can talk about it generally without discussing the specifics, but if we need to go there, that's what we will do. Apart from that issue, as what I intend to do is kind of break down the trial process through stages. And as you have issues or questions about whether how to handle something or how the court handles something, that's your opportunity to ask as it relates to that phase of the case. And we'll just sort of proceed in that fashion. So starting with some general issues, I just wanted, and a lot of this is unfortunately going to sound like me simply lecturing about what I want and don't want. And that certainly is a large part of it, because if you know what I expect, I think it makes your job easier. And so I, particularly where I can't recall whether Ms. Massoff has had any trials with me or not, but I know she's been in front of me a few times, but the rest of you have not. And so it's, I think, important that you get that information straight from me rather than from the sources that you may get from asking around. So to start with, I'm not a fan of surprises, as you may have figured out by now. I want to know in advance, as far as possible, when there are issues that need to be addressed. That includes evidentiary issues. So if you know that you're going to object to some line of evidence, or you anticipate that there's going to be objections to a line of evidence, I don't want to wait until that is offered in the middle of trial for a couple of reasons. One, I don't have the opportunity to look at the issue to the degree that I would want to in order to give you the best ruling that I can. And two, it doesn't give you the opportunity to make the best case for me that you can for either excluding or overruling any objection. And perhaps even more important than all of that, from my perspective, is in what is already going to be an quite lengthy trial, it just extends it. And nothing frustrates jurors more than sitting around in the juror room doing nothing while we're in here doing something. And so that helps guard against that and minimize that amount of downtime that we may have. So we'll have periods, as I will explain to you, before court each day and after court each day, where if you are anticipating issues that are coming up, that's the time to talk about that, not in the middle of the trial itself. I did receive the parties' stipulation regarding how to handle the IGG tip, if you will. I'm fine with that proposed instruction, and so that will be given. I think I'd asked you also to work on an instruction related to the use of the terms surrounding touch DNA and other variations about that in the event that I decide to correct somebody about the use of that term. As I said, with respect to the professionals in the DNA community itself, I'm not going to prohibit it in the sense that, you know, I'm going to sustain an objection. What I would likely do is to clarify with the jury, if the parties want me to, about that being simply a convenient title and not meaning to imply an actual source of or method of the DNA being present. And so if you haven't worked on that, please do so to get me an instruction you both can live with. Otherwise, I'll end up drafting one myself and perhaps neither of you want to live with it. So with respect to the model, I think referred to as the dollhouse by Mr. Thompson, has that been produced for the defense to inspect?
It has, Your Honor. It's actually here in this courthouse, has been for a few weeks, and Mr. Herwood facilitated the defense viewing it yesterday.
Okay.
It is available for the court's inspection well if the court would like to look at it. And just for the record, to the extent that the model was characterized as a dollhouse, I think that was an inappropriate characterization. It is an inappropriate characterization. If I'm responsible for it, I assume responsibility, but that's simply not an appropriate way for it to be described, given what occurred there and the victims.
I think a better term is simply a model,
Yes, sir.
rough model, given that it is admittedly not to scale precisely. So, Ms. Taylor, any record about that? You had a chance to look at it?
Your Honor, we did. We were able to bring 2 experts in for our request yesterday, and we appreciated being accommodated while we were here. We do have a remaining question about where the model house will be stored during the course of trial.
Where are you storing it, on the 3rd floor?
Yes, sir.
Okay. So it sounds like it's stored with the evidence vault of the prosecutors down there. And so I suppose if she needs to get access, or our experts do, we can arrange for that as well.
I should have asked a better question, Your Honor. When it's brought in
I
as a
see.
demonstrative aid, I am curious about when it's not being used by the prosecutor or the defense and a witness, where it will sit in the courtroom.
I will find some place not in the courtroom, because I don't want it in the courtroom when it's not being used, but nearby in the event that a witness does wish to use it.
Thank you, sir.
The other thing that I would point out, as it sounds like you've been, at least to some degree, working together, and I appreciate that. As you come to stipulations on agreement on things, it's important that those be reduced to writing for your own protection. Because too often what I see is in the middle of, for example, trial, well, you know, Honor, the other side said that they were going to stipulate to that, and then they're not. That leaves me in a difficult position, because I wasn't part of those discussions, right? And so for your own protection, I think it's just important that you get those reduced to writing as much as possible. I did receive the parties' spreadsheets on the exhibits, which we'll go into a little more when we get to the exhibits portion of today's menu. But I appreciate getting that. There's some questions that I had about it generally, and then some more homework to do on it. In terms of the witnesses, I had asked, and I think my law clerk reached out to make sure that we get a description of those witnesses, kind of like if they're who they work for or where they're from, something that will allow me to categorize those on a juror questionnaire so that they don't just get a list of, 300 names, but can say, all right, these are witnesses, these people live in Pennsylvania. These are witnesses that work for the FBI, these, right? And so that they can put in context those names, which will be result in a more accurate review by them of those names to see if they know anybody. And I'm not sure if that's been accomplished yet or not. And so if you haven't done that, please get that to us as soon as possible so we can incorporate those. I think the state had, and last I heard, but it's been several days, the defense had, we were still waiting for someone from the defense.
And I believe that that's been provided. My hope is that it was sufficient because I think it came back and we re-provided it.
Okay, I'll check.
If it's not sufficient, let us know.
I'll check on a break to see where it's at. All right. So I did, as I indicated this morning, receive the defense's proffer regarding alternate perpetrators. That will be sealed per request, I'm assuming per stipulation. And I want some additional information there. What I'd like is by the 23rd, if possible, for the defense to do two things. One, provide me with whatever actual evidence you have that supports those allegations, rather than just allegations. And two, provide for me how it is you believe that what you are offering is admissible. Because it seemed to me much of what you had put in there was fairly potentially fairly objectionable in terms of admissibility. So I would like to see that. And then I would have the state respond by the 6th, which is 2 weeks. And then I would propose a hearing on the 18th.
Your Honor, on June 18th, Ms. Massout has a conflict in the morning, but we could do an afternoon hearing on that day.
Can we do the 20th? The 19th is a holiday and the court is closed. I'm just not sure whether it can be done in a half a day or in the afternoon or not, depending upon where we're at. That's my concern.
Your Honor, for me personally, the 20th is a little bit of an issue for personal reasons. If we could avoid that date, if we can't, then I guess we can't.
Well, let's, can we start by like noon on the 18th?
12:30 or 1. I'm in federal court.
Let's do 12:30. Are you handling those issues?
Alternate perpetrator. I'm, yes, very involved.
Let's do 12:30 on the 18th. All right, next I want to go to juror questionnaire discussion. Before I do that, this was that was, as I said, sort of a catch-all category. So I want to ask you if you have questions now, because I suspect it will fit into, if you do, a more specific category, and we can address it at that point. But if you have a question or concern about anything we've talked about thus far, now's your chance.
I don't believe so, Your Honor.
No, Your Honor, thank
Right.
you.
All right, juror questionnaires. Otherwise, I'll end up drafting one myself, and perhaps neither of you want to live with it. So
I had a backup ready.
with respect
Fuck
to the model, I think referred to as the dollhouse by Mr. Thompson, has that been produced for the defense to inspect?
It had-
Because it seemed to me much of what you had. All right.
This happened on every stream. What the fuck? It crashed. I told you they weren't going to be able to do it like this. They need to run it through YouTube. You got to be shitting me. What a bunch of fucking idiots. What a bunch of fucks.
The reason I
And then we will bring them in to fill out the questionnaires, beginning with one. So that the questionnaires that you receive first will be the jurors most likely to be in the line of fire, so to speak. Because once we have enough jurors, we'll stop. So that's the plan. Anybody have any concern with that?
No, sir.
No concerns, thank you.
Technically, under the are entitled to watch the scramble process, which literally involves the jury commissioner hitting a button. I don't know if any of you want to be there for that.
No, thank you.
We'll waive our presence for
All right.
that, Your Honor.
Very well. I do want to stress the security and confidentiality of the juror questionnaires, as I'm sure you're aware pursuant to Criminal Rule 23. Those are extraordinarily confidential. The copies that you receive will be, we'll maintain a copy, obviously, for appellate purposes. The copies you receive will be returned. The defendants, they're supposed to be essentially attorney's eyes only. I'm fine if you both agree to allow an investigator to see, so that they can be doing, whatever online investigation they feel appropriate as you go along. Doing that, in terms of the defendant, his access has to be with attorneys present. In other words, he can't have a copy or whatever to go back with him when he's not with you.
That makes sense, but I have one question for the
Sure.
court. In addition to our investigators, we have 3 that are working on the case. We would request our paralegals be allowed to assist us. Just with the magnitude of the task, we'd like to have the assistance of our paralegals in organizing and reviewing.
Sure.
And likewise, Judge, we would hope to use our administrative assistants in the process, and they are part of our staff.
Sure, and by court and bar rules, you're responsible for their conduct, and so you'll need to make sure they understand the confidentiality of those questionnaires, and it's really your ticket on the line for their behavior. So that's fine. But I do want to stress that confidentiality, because it is part of what I'm giving the jurors on the instructions, is letting them know that there's a very limited number of eyes that will review this, and that the public never will. So. The plan will be to try to process the first questionnaires. As I said, you'll get them each day and go through them. After 3 or 4 days, we will start to have hearings. Those will be sealed hearings because we'll be going over the questionnaires in detail, in which you folks identify the concerns you have with the questionnaire answers, specifically whether there's a motion or agreement to strike a particular juror before we ever have to bring them in based upon the questionnaire answer, right? And the idea is to dismiss those who are unlikely to be put on the jury because of either perceived bias, knowledge of the case, or hardship. And so, I think it helps everybody if we are trying to agree to that as much as possible. It's the reason that we are summoning as many people that we are, is so that we can really cut through the chaff and get to the wheat. Any questions about the juror questionnaire process?
Sir.
Is voir dire open to the public? That's my only question. Is voir dire open to the public?
So the next topic I have is voir dire, more specifically.
Here we go.
you know, traditionally, the way, as you know, voir dire works in Idaho is the court first does its voir dire, touching on some essentially statutory kinds of bias or knowledge. And then counsel is given that opportunity. And so much of what would be the court's voir dire, I have incorporated into the questionnaire so as to limit my role in actively questioning the jurors or potential jurors. I may follow up on some of the answers given on the questionnaires if I feel there's a need to. But otherwise, the time will be yours. What I intend to do, and I'll get your input on that, is using a model very similar to the model Judge Boyce and I came up with in the Daybell case, bringing in groups of anywhere from 15 to 20 people at a time, having a general session of questioning by the attorneys, approximately 30 minutes aside of those folks, get through challenges for cause or dismissals for hardship, et cetera, of those folks. And then who's ever left over of that group then would be subject to individual questioning by the attorneys. And so the jurors that are left over will be taken to, for example, the jury room and wait in there. And then we'll bring the jurors in one at a time to answer questions from counsel. The goal is, I'm not going to stop you if you're getting important information that needs to be got to. But the idea is after that more group discussion, the individual voir dire will be more for very sensitive topics, also for knowledge they have about the case from media or otherwise, because I don't want them to talk about it in front of other jurors. And then other topics that you sense were too sensitive to talk about in front of the others. Hopefully we can get through each of the individual jurors in 10 to 15 minutes apiece, but we'll play that by ear. We'll see.
Ask a question.
Sure.
So the 10 to 16 people in the general session, is that going to be the court's few questions and then each counsel has general questions? And just to make sure I understand, then whoever's left from there, we pull in and then we talk about case specific information, the media items.
Media items, correct.
Okay. And would you envision that during the time we talk about media items, I can also find out their views on capital punishment?
Yeah, it may be that you are able to talk about that with the larger group to a degree. There may be some who appear sensitive to that and prefer to talk about it outside, and we kind of play it by ear. So it's not a subject I'm going to forbid from being discussed in front of the larger group. And you'll have limited time with the individual. So, you need to balance how you're going to use that time.
We may have to see how it plays out, Your Honor, but in my view, talking about the views on capital punishment is fine in a bigger group. My preference would be to be able to get the media items, people that aren't going to make it, to let them go before we do that. I think it would save time to have them gone before we do the capital punishment views. If we know they're not coming, they're not going to stay because of media coverage and those kind of beliefs and views, it makes more sense to have them go before we start talking about something else. My concern is the amount of time and that the media coverage items might find their way into a discussion of capital punishment.
Well, I will make it clear to the jurors that they're not to discuss anything they may have heard in the media during that general session. And we'll play it by ear. If it's not working, we can change it, right? So let's, and this is very similar to the way Judge Boyce had done it. I think it worked well. They got a jury fairly quickly. Now, as much as the attention was in that case, obviously this one seems to have more publicity. But I think that handling it with first going through the general, because we're going to lose people based on hardship, based on, have they made up their mind? Yes, right, kind of stuff. And so we don't even need to talk to them. And then we can get into the issues, or they may, simply give a view of capital punishment and that one that it's clear that they're not qualified, either one side of the coin or the other. But if you want to deal more, if they're hedging or you're sensing some concerns, you can use that follow-up time in individual session to follow up on that rather than trying to do that in the public session. Any questions about that, just in terms of how the questioning will go? So my intent in terms of public access to the voir dire process is that during the group session, victims and defendants' family will be present. A small number of public seats will be available. And then it will be streamed to a larger room in the courthouse for anyone else in the public that wants to watch. It will not be broadcast outside of that closed circuit, because then I lose control of the recording in the event that a juror's identity is revealed, and then I get all the internet sleuths out there trying to figure out who everybody is. And I want to protect the jurors' privacy as much as possible in that regard. And so this does allow for a public access is the right, but also allows the court to tightly control that process. And then
Woo, I'll be there. Yeah.
the individual voir dire will be counsel.
Great news.
And there'll be no stream.
Potential jurors' faces and names obviously won't be broadcast.
Correct. The faces will not be broadcast, and you are to only use their scramble number as their identity throughout this. So they will never, you will never speak their name, nor will I or the court. It'll only be by that scramble number, and the camera view will not show their faces.
The juror number by which we'll name them, will that be on them, or does this court use paddles so that their numbers can be held up when we want
They'll
to
have a
register?
laminated paper, like 8x10 paper that has cardstock laminated that has the number on it. And it'll be the scramble number, not their original reporting number. My goal is to try to get through 4 panels a day, which may not seem like it's much, but I know from the prior trial that they struggled to get 3 a day. So my goal is to try to get to 4 a day, but I want to get at least through 3 panel a day. The plan would be is once we get through the number of jurors we need to sit, including alternates and peremptory challenges, plus a few extra in the event something changes before the time we exercise the peremptory challenges. Once we get that number, let's say that number is 50, that's where we would stop and then go to the peremptory challenges. Does that make sense? Any questions about that?
Just to clarify that I understand it, we'll get enough people that we get 50 that have not been challenged for cause and then
That have been
exercise
passed for
peremptories.
cause, correct. So once you get that, if you will, struck panel, then we will exercise the peremptories. With respect to the number of jurors, prior to Friday, I had intended to use 6 alternates, and after Friday, I intend to use 8 alternates for a total of 20. That's about the maximum that I can fit into the jury box that we intend to use. So that number, 20 plus strikes, which would be 12 strikes apiece pursuant to rule, gets us to, I think, 44. And so the plan would be to get, 50 to 55 that have passed for cause to bring back for the peremptory challenges in the event that we lose somebody for some reason in between. Any questions about that process? Okay.
$12 strikes per side for any reason. Is that what we're rolling with?
So, and then when we're exercising the challenges, what I do is I give you a time limit geared to the number of peremptories that you have. So here, for example, you have 12 peremptories, give you each 30 minutes to exercise those. And it's a chess clock. So while the paper is with you, your clock is running. And once you hand it to the bailiff, it stops running and the other side starts running. Once you reach your 30 minutes.
Oh, this is a good way. This is sweet.
Absent some showing of something happened outside your control, then your peremptories are over. Now, that's usually I give 1 minute per peremptory in the typical trial. I'm giving you far more than that here. It shouldn't take that much time, particularly with the number of people that you have keeping track of everything.
Oh, this is going to be great. This is so sweet.
If you both pass on a round,
Okay.
or let's say the defense passes at the end of round 4, and then the state passes at the beginning of round 5, that ends the use of peremptory challenges, because you both have said to me, by passing consecutively, there's nobody that you want to strike. So understand that that rule as you go in. After the panel is selected, the jurors and the alternates, which the alternates won't be determined until deliberations, when by lottery, who's ever left will be determined to be the jurors, and the alternates, those who are drawn by lottery to be an alternate. But that group of jurors, and so the 20, will be taken to another location in the courthouse. I will briefly meet with them, simply to introduce to them the people that will be talking to them, which will include the trial court administrator, the jury commissioner, and Judge Cawthon, who will be acting as it relates to this case as the administrative judge during the trial, to help them understand the process that we will use for juror security, for juror privacy, for reporting, and all of that, to answer any questions they have about that process, so they know where to go to ask questions about the process, and sort of, if you will, onboarding them. Counsel won't be at that, nor will I, other than to introduce the people. And then I will leave so that I don't inadvertently hear anything that I shouldn't hear on my own. I want to stress the importance of no contact with the jurors in any way by you, your staff, your witnesses, anybody affiliated with the case. And so they need to be instructed as to that. So if the juror, if you happen to see a juror somewhere else in the courthouse or at the grocery store or at the coffee shop, you're not to even engage in pleasantries. Turn tail and run the other way as fast as you can. If you have any contact with the juror, you need to report it immediately to myself and to opposing counsel, so we can then make any inquiry that we need to. I issued yesterday an order in this case regarding sort of the rules of the road for those attending the trial, as well as an administrative order that I imagine will be on the court's website here, if it's not already, outlining some of that as it relates to outside the courtroom. So my order in this case relates to the courtroom. The order, as I signed as administrative judge, relates to the courthouse at large. Make sure you have reviewed that and make sure your team understand that. There will be portions of the building that will be off limits to the public and to you. So make sure you understand that as well. I think I told you when you were here to look at the facilities, it's important that we know where it is you intend to stay as soon as possible, as well as any witnesses you put up, et cetera, so that to the extent that we ultimately may need to sequester jurors, which once it goes to deliberation, we will have to at a minimum, that we steer you away from whatever series of hotels that we've reserved as potentially available for us to use, that you're not there. So let the staff know if you intend to stay at a hotel, if you intend to put witnesses up at a hotel, intend to have staff stay at a hotel. Let us know where that's going to be. You will each be assigned a conference room outside the courtroom, and you'll be given a key to it that you may lock each day, that nobody, including janitorial staff, will have access to, where you can keep your papers and files if you'd like, or other materials, and to use to meet with witnesses, et cetera, as we go along.
What type of access do they get
All
to
right, before we
Kohberger?
turn to the trial itself, any questions about the jury selection process or the jurors?
No, sir.
No questions, thank you.
So the trial itself, the plan is to go from Monday through Friday with the session with the jury beginning at 8:45 each morning and ending at 3:30. Once we hit a sequestered phase, whether that be, for example, in a penalty phase or earlier in the case, should it become necessary, I will likely extend the hours of the trial to fill up the jurors' days. Part of the reason to give some time at the end of the day is so that they can do the errands of life that they need to do. But if we are hosting them, so to speak, we don't have to worry about that. And I'm sure they'd rather have their day taken up moving forward on the case. So that is the general plan. Counsel and the defendant dressed, ready to go at 8:15 each morning. From 8:15 to 8:45, if there are issues to discuss, that's when we will do them before trial starts. As I encouraged you when I first started this morning about this, this would be a really good time to discuss anything that you've just uncovered that might be an issue in the case. We will likewise have a period at the end of the day from 3:45 to 4:30-ish to similarly address issues that may be coming up the next day or in the near future. At this time, I do not intend to have trial on October 2nd and 3rd. Because of a previous commitment that I have. I had talked to you before about potentially being gone on the 14th and 15th. As of now, I've been able to make alternate plans. So for now, you should plan on being here for trial on those days. Holidays that I could spot quickly on the calendar include September 1, October 13, and November 11. So those are holidays for which there would be no court, with the exception that if we are sequestered, we may have trial, and we'll address that as we go. Because I can't send jurors home for the holiday, and so we might as well use the time. Any questions about that trial schedule? Okay. All right, in terms of special needs that you may have for a trial, I'm assuming there is no need for us to have interpreters for any witnesses.
No, sir.
And then technology needs, be sure that you make sure whatever technology you intend to use works in the courtroom in which we will be. The best way to do that is to contact Ms. Barrios, the trial court administrator, and reserve a time to come down and try it out. I also suggest that you use on your team somebody that is far more technologically savvy than certainly I would have been in your shoes. Perhaps you are, but it's important to have your own IT kind of person there to deal with any issues that may come up. If you have litigation presentation software and it's not working, you might get a short recess of a few minutes to work it out. But if it's after that, we're just going to move forward and you'll have to figure out something else to use. So it would behoove you to have staff there that can deal with that. Likewise, in the event that something comes up last minute and there's a need to redact some portion of audio or video or other presentation, that you have somebody there that can do so quickly and knows how to do so quickly. And I would encourage you to plan ahead to have alternate versions of such things so that if there is a concern that's unresolved going into it, you have version A and version B you can use depending upon what the outcome of that may be. Any questions about technology?
Hitler's just plowing through everything
In
like
terms of what we provide, it will be a overhead, what we call the Elmo device,
Elmo,
which is the device where you set a piece of paper down and it projects onto the screen.
aka Hector baby.
And then we
Hector.
have a HDMI link for your computer to present whatever you want to from your computer. That's it. That's our technology. So anything beyond that, you'll have to bring.
Hector's a beast.
Let's talk about seating in the courtroom, counsel table, and the trial broadcast. Each side, I think when we toured the courtroom, each side will have two counsel table kind of put together, which should give you, depending on how closely you want to sit together, anywhere from 4 to 5, maybe 6 seats at that table to use how you wish for yourself and your staff, and in the defense's case, the defendant. As I also indicated, I would provide a small table behind defense because they're not really as close to the bar as the state would be. A table behind you where you can have staff, 2 to 3 staff members. The state will have some room behind the bar, directly behind them for its staff. What I need from you are numbers. Understanding the space that you have in the well. How many seats do you need? How many seats are you requesting and how many seats do you need are two perhaps different issues. But in terms of requesting, this does not include, for example, the victim's family or the defendant's family, but for staff. So apart from the 2 or 3 seats behind you, I'm assuming that's enough for you. For the state, likewise, 3 seats, 4 seats.
We should be able to make that work, Judge.
Um, in terms of reserve seating for the victims, it will be for those statutory victims that was agreed to by the parties. And for the defense's family, it would be those 4 members that were identified in terms of reserve seating. What I would like to do, though, is I suspect that it's maybe that everybody won't be at trial every day. And so what I would like, excuse me, is for those that have reserved seating, in particular the victims, and I should point out I am going to reserve 2 seats for the 2 surviving roommates who are technically victims of the burglary. I don't know whether they would have any desire to be here. I suspect not, given the way they've been treated in the media. But if they do, that they would have seats available. But anybody who has reserved seats, I'm asking that they notify the trial court administrator what their plans are for each week.
What the fuck?
If you tell me you're not going to tell the TCA, I would like to know, for example, we're not going to use 3 of the seats on Tuesday. So that we know, so that we can make those seats available for the lottery system, or it's not technically lottery, it's a first come system on a computerized basis. But if we don't hear from you and you haven't made arrangements, we will assume that you don't intend to be here. So it's important that each week you let the trial court administrator know. She'll give you an email address if you contact her, where you can send an email to tell us whether you'll need all of your seats or not that week, and at which days you won't. That goes for both the victim's family and the defendant's family. Right now, the plan is, and this is subject to change, to have a reserved seating, I don't want to say reserved seat, a seat selection process by which people can go to a website each day and at a certain time, and it's kind of like buying concert tickets, indicate a desire to have a seat, and the first X number that are available that get through will have a seat. It will be necessary to bring identification to show that you are who you are, or are who you say you are, to get into the courtroom. Again, that may be subject to change. I think the intent is for Judge Cawthon to have a town hall meeting with media in June at a date to be determined later, to go over sort of what that process looks like, so so the media is aware, and so that then it gets publicized to the general public that would want to be here. My intent at this point is to allow a stream of the trial proceedings controlled by the court to
Boom.
be run on the court's, where, if anybody's watching today, where it would be today.
Woohoo, there it is.
Court's broadcast page.
It is live streamed.
The views will include counsel table, the podium, the witness stand, and the bench. There will be no production of the video, meaning there'll be no close-ups and zoom ins and zoom outs and things of that nature. It'll be the static views.
Before the court goes further, when we're talking about the reserved seating for families in the courtroom, if we have some other members of Mr. Kohberger's family that travel and want to attend the trial, can we request an extra seat for a day for them.
Yeah, we probably be able to accommodate a few days here and there, but seating's going to be very limited, right? And so I don't want to extend that beyond the immediate family as a general rule, but if there's a specific day or two where there are going to be a couple other folks in town, talk to the trial court administrator and she'll see what she can do.
In addition to that, we have one other person on our team that would like to have sit with the victim or with Mr. Kohberger's family. It's not somebody who would testify. So if we could have 5 seats, it's somebody who will just assist them, as the media might try to talk to them
Sure.
a lot.
All right,
Thank you.
I don't have a problem with that. I'm assuming the victim witness coordinator will want to be there as well, so.
And Your Honor, as the court is aware, we have, unlike most cases, we have multiple victims here. So we will have multiple victim coordinators to work with separate families. We will coordinate that with Ms. Barrios' office to let her know.
Are you talking about one per family?
Hopefully not like that, but we're
Thank
going to need to split at least, we're going to need to have at least 2 separate groups.
All right, let's try to keep it as limited as we can, just because seats are at a premium, but.
Yes, understood.
Why do we
Your
need 2
Honor,
separate
may I also
groups?
ask the court in regard to the live stream from the witness stand. I believe that we mentioned this at least in passing in our trial brief. State anticipates that we may have witnesses who, for reasons the court articulated about the other 2 victims, surviving victims, that public live stream where their images could be captured and played games with in the media world. Is it possible for the video of that live stream when they testify to be shut off and just have the audio? We also may have a small number of law enforcement witnesses who also do covert work, and broadcasting their images publicly would be undesirable. We will advise the court. We've asked the agencies to identify anybody in that capacity and to specify the basis, which we'll bring to the court. I just wanted to give Your Honor a heads up.
What's
Your
the
Honor, this case is very high profile, and we've had people who have expressed reluctance to talk to us and being willing to testify for similar reasons. I did have a chance to speak with the state this morning, and we agreed that what we'd do is take a look at our entire witness list and try to figure out people that might be more sensitive to having their video camera on their face while they testify. And we may approach the court with a stipulation for certain numbers of them.
Well, my intent would be with respect to victims, and I've already indicated, I think the 2 roommates are victims. There is a compelling interest to protect them. And so just as typically when media is present, they're not permitted to photograph or video victims that may be in the courtroom. If the victim requests it, their face will not be shown during the broadcast. In terms of those that work covert, I gotta see where the parties land on that. If they weren't covert in this case, I'm not sure about that. I'll have to think about that, and you may have to convince me, because I think there is public interest at play here. And so we'll talk about it.
Thank you. Yes, sir.
And as for anyone else,
Well, that's good
you're
news
gonna
for
have
us.
to really convince me because of the public's right.
Yes.
And,
Yes.
their
There you go.
hesitancy can be overborne with a subpoena. And that's what subpoenas are for. So I'm probably disinclined to do that in general for other witnesses. As you can see, I'm even hesitating with people that may have a line of work that is undercover if they weren't undercover in this case. So other folks who may be shy, probably I'm going to have to weigh heavily the public interest there.
Your Honor, I wonder if the same could be accomplished with a room where there could be a feed for certain bits of testimony to a larger group. And it's still a public open courthouse, and live streaming something that gets captured for millions of viewers that lives on for a very long time might be different. And I can work with the state and then give the court a little bit more on that, but off the top of my head, that's what I'm thinking.
It's going to have to be a very compelling reason to do it. So aside from victims, um, you know, while we are open in the sense that the people in the courtroom, the likelihood is we can't fit everybody in there that wants to be in there. And if I start not broadcasting the testimony, the full testimony of people who would otherwise prefer not to, that's going to fill up, that's going to be a large number quickly. And the best way that we have to ensure that the public is accepting of whatever verdict may be reached in this case is for the public to have the ability to see the evidence. So I'm not saying no, I'm just saying you're going to have to really convince me.
Thank you.
All right, any questions about either the seating or broadcasting besides what we've talked about?
No, sir.
All right, let's move to then opening statements.
Opening statements.
Let me start with what you've probably figured out by now. I am not tolerant of argument during opening statement. So if somebody is arguing and there is an objection, it will be sustained. Please don't do it. What I would like you to do is, by about the time that we're meeting again to select jurors, let me know what you estimate the time you need for your opening is. I will then look at that request and give you a time allotment based on consideration of that request. Each side will be given the same amount of time, and then I will hold you to it. In other words, if you tell me it's going to take an hour, I'm not going to tell you you only have 30 minutes, right? But if you tell me you want 5 hours, I might have some questions about that. But if you tell me you need an hour and I give both sides an hour, in about an hour, you're going to hear me say, counsel, you've got 5 minutes left. Use of exhibits or potential exhibits during opening statement. Because exhibits are not pre-admitted, even if stipulated to, there has to be an agreement to show the exhibit during the opening. Hopefully you both work together knowing what is coming in and isn't coming in, particularly where there's an agreement that something's coming in, other than spite, there's no good reason to not agree to it because the shoe will be on the other foot, so to speak, down the road. So courteous typically pays off with reciprocal courtesy. So work together on that. But technically, if it's not admitted, which nothing is by the time of opening, and there's an objection to using it, I would likely sustain it. For that reason, it's important that you, if you're going to use, for example, like a PowerPoint or something like that, that you share that with the other side at least 72 hours in advance so that they have a chance to review it and then work out any concerns they have and lodge any objections that can't be worked out with me, 48 hours in advance, so that I can then look at it and make a determination. If I haven't given you a ruling by that time and you're coming into openings without yet having a ruling, I suggest you have more than one version ready to go. One that is anticipates the objection being overruled and one that anticipates it being sustained. Let me reiterate again, please do not argue during opening statements or in voir dire, I should mention as well. Make a request at the beginning of your opening to enter the well and it will be granted. However, an invitation and permission to be in the well is not permission to invade the personal space of jurors. So understand that and stay a few feet back, at least from the bar of the jury well. If you are going to use a PowerPoint or some other presentation, you need to choose at the beginning of your presentation whether you want the lights on or off, and they will remain that way throughout your opening rather than turning them on and off again. So I suggest you do a dry run based on what the light looks like at that time to see what that looks like, to see if you want it on or off.
Dry run, baby. They always care about these damn lights. What is with
Any questions
judges
about openings?
about their damn lights?
All right. Next, I have witnesses. Before we do that, let's take a break. We'll take 10 minutes and I'll be back. All right.
Okay, break time. Break time, and then we got witnesses. Okay. This is how my courtroom's going to be ran. All right, well, let's take a look at this. Those of you guys just joining us, the public session began at 11:33 a.m. Eastern Standard Time, 9:33 a.m. Mountain Time. He says, no surprises here. If you have evidentiary issues, you're going to bring it to me ahead of time. That way I can help you out ahead of time. Do not wait until it's offered. Not a smart move. They determined that they stipulated to the IGG and the proposed instructions he is fine with. We will find out what that is down the road. The Dow House will no longer be referred to as the Dow House. You guys hear me? The Dow House. No more calling it the Dow House. You understand that? The Dow House is a model, rough model. Okay. It's now a rough house. So rough housing. And Bill Santa took one on his back there and said, if it's my fault, it's my fault. Okay. Ann Taylor brought in 2 experts to check it out yesterday. Joshua Hewitt walked them over there to take a look. It'll be kept on the 3rd floor in the evidence vault, and it will not be in the courtroom unless there is a witness speaking about it. The Dow House, again, is no longer called the Dow House. The Dow House is called the rough model. I don't give a fuck. I will say whatever I want to say. But in the courtroom, I will refer to it as a rough model when I'm there. Judge Hippler said, listen, if you guys are going to agree to shit, you need to do it in writing. You need to do it in writing. Because if you don't, you guys are going to end up screwing each other over. Next. He wants a list of the 300 witnesses, and we are going to be describing these people. We want to know where they live, what they do, who are these people. That way the list of 300 witnesses can be appropriately, because you asked the people that are on the jury, potential jury, you asked them if they know of any of these people. So that's what that's for. There was a proffer, and it was sealed for the 3rd-party culpability. We got to that at 9:58 a.m., right about. So into an hour into it, proffer is sealed, and it's for the 3rd-party culpability. Judge Hippler wants more information on this. He said, number one, I need evidence of the allegations. And number two, I need to know how you believe what you have is admissible, because I believe it's fairly objectable. So you're going to get me that stuff by May 23rd. Then the state has till the June 6th, 2025 to respond. And we're going to have a hearing on that on the 18th of June. The 19th is a closed holiday, so we're not going to be here. We will start the 18th at 12:30 because Miss Mathis is going to be in federal court, and she is mostly handling the third party. And then we're going to move to the jury questionnaire. The jury questionnaire are voidare. The questions of the jury. So what we're going to do is we're going to run it like we ran the Daybell case. Okay. You're going to have 15 to 20 general questions, or like jurors coming in, potential jurors. And then you're going to be able to question them. Each lawyer, each side is going to be able to have 13 minutes. And how you're going to do it is like a chess match. So when it's your turn, you're going to have your paper in hand, asking whatever you want, clock out when you want to clock out. Then the other side takes on, and you have a running clock. Then we're going to get down to 10 to 16 general jurors then. And that we are going to then talk case specifics, because we're going to eliminate people for reasons of, hardship, things of that nature ahead of time, as well as that they already formed an opinion, things like that. So when we get down to that 10 to 16 general session of the jurors, we will talk case specifics. And that's when we're going to be talking about the media items. And we're going to hear what people have read, seen, and heard in the media. We are possibly going to keep the capital punishment talk out at that point, but it could possibly be in. And Taylor thinks it goes hand in hand. Hippler says he's going to have about 4 panels per day. And that he, on Friday, said, I will roll with 6 alternate jurors. He decided Monday he is rolling with 8 alternates. So we're going to have 20 total jurors, and we're going to get to a point where we get 50 to 55 that have passed cause that we have in this pool. And then we are then going to chop off at the legs one by one. Each side is going to have 12 strikes per side for your peremptory challenges. And again, it is going to be a clock chess match where you're roughly rolling with like a minute to 3 minutes per person. You will have no contact with the jurors. None. If you have contact with the jurors, you are to report to me immediately. Each side will have a conference room right outside the courtroom where they can keep their files. The janitor doesn't even get the damn key. So you do not have to, this is for you to, freshen up, use some breath mints, meet with your witnesses, things of that nature. And this is for you to keep your files. Poor Mathis rolling in those that luggage every day. We will have court Monday through Friday. 8:45 a.m. begins jury session with the jury here, and we will go until 3:30 p.m. Between 8:15 and 8:45 a.m. Monday through Friday, the defendant will be dressed and ready. If there's any preliminary matters, we can take those up between 8:15 and 8:45. But the defendant will be dressed and ready to go at 8:15. Then when we close at 3:30, it's for the jurors to get their daily errands in. We will then allow from 3:45 to 4:30 if there's any issues. There will be no trial October 2nd and October 3rd. As I told you guys ahead of time, I have a commitment. There will be no court September 1st, October 13th, or November 11th because those are holidays. But if we sequester the jury, well, we will not be observing those holidays, and we are going to ram through that shit. So we will not be having holidays, and court will be in session. If anybody has any special needs, speak now. Nobody spoke. Special technology, if you have needs, make sure you get with the tech personnel. I suggest that you have your own AVI person. So do I. Hippler said we are giving each side an HDMI cord to plug into their computer and an Elmo device, which is like a Hector. That's it. The rest you will figure out. And if you think that you're going to delay my court a couple minutes to fix an AV issue, okay. Anything past that, we're going to be moving on. Fuck your defendant's rights. Now, broadcasting issues. This court will broadcast council table. There'll be 4 to 5 to 6 seats, depending on if you're a large woman or a small man. You will have a small table behind you for the defense for 2 to 3 staffers. Please let me know the number of people that you guys have so we can make sure that this all flows properly. The victim and the defendant's family, they have their seats that we've already talked about. If you're reserving seating, okay, that is a very special process, and it's like a concert. Good luck. We will allow 2 seats for the surviving roommates. They survived a burglary. And we will allow 2 seats for the whole trial. But I doubt that they will want to be in here seeing what they have endured in the media. Remember, these seats in this courtroom will be a first come, first serve system, and it's a computerized system. Each week, you will tell your representative, if you are not using any of your seats that are already reserved, please let us know that. Make sure you tell all of your people to have their identifications on them, as you will have to show your ID. You will have to claim who you are. Now, June is Media Day. I'm sure you guys don't want to be here for that. But there is a Media Day. So that is where anybody with the media can be told how things will be ran. Now, for jury selection, there will be the room in here, but I will also have a huge viewing area that's in this courtroom where whoever cannot be seated in the courtroom has a view of the big screen and will be able to watch it there. It will not be live streamed, but it will be in the big screening room, so to fit as many people as possible that if you are physically here. We will have camera angles for a live stream that will be seen right here on my channel. And it will feature the podium, the witness section of the courtroom, the 2 benches, my bench, your guys' wells over there. And there will be no close-ups, so don't worry about wearing any makeup. No zits will be seen. The only people that I am permitting, unless you are able to convince me otherwise, will be Dylan and Bethany. We will only show their audio. There will be no video for them. Everybody else, this is a public trial, and there's a lot at stake here. During opening statements, nobody will be arguing. If you argue in your opening statement, meaning if you're trying to make an argument, it will be sustained if it's objected to. I have a very, very sensitive eye. And so once those lights come on or go off during your opening statements, you are to keep them on or off. We're not going to be playing flickering lights. If you want to be using an exhibit in opening, it has to be agreed to, and you will be sending each other those things 72 hours in advance to review, such as like a PowerPoint, things of that nature. Break time. There you go. That's a pretty good cap, you know? Pretty good cap. Woo! Any questions? They're taking a break. They'll be back in a couple minutes. I'm liking his rules. I'm liking how he knows this is a public interest. There's so much public interest in this case, and he is not just going to let people say, "Oh, I don't want to be on camera. I'm not going to be on camera." Nick, no, none of that's happening. Okay, you're taking the stand. You're testifying. We have subpoenas for a reason, and you'll be hauled the fuck in here, and you'll be testifying. Okay, I'm not going to play these little games, and we're not just going to let people say that their face is not to be seen. That's not happening. So I love it. You guys, that's a really good ruling for everybody who wants to watch it like streaming, you know. There's a large, huge public interest, lot at stake here, lot of corruption on the line. Was there corruption? Is Ann Taylor and her team just blowing smoke up everybody's ass? What is going on? So next up after the break is we're going to be talking about the witnesses. So I'm interested to see what we're going to be talking about with the witnesses. We talked about hotels. We talked about some hotels here. He wants to know where everybody's staying so that we're not putting witnesses in hotels that the state or the defense is staying at. So he was talking about accommodations. We have no buffer zone. Okay. So we are flying we will be having a tailgate if I'm there, the weeks that I'm there. We'll be having a grill. We'll be having hot dogs, brats, gyros, and cheeseburgers. Okay. We'll be right there. There's a Whole Foods parking lot. We're going to go get our vendor's pass. And we're tailgating. Tell me that I can't tailgate. Tell me that I can't tailgate. Thanks for the recap. I missed some of that. Oh, good. Glad that helped. Lana, do you have thoughts on who the defense named as alternative suspects? No, but I think hearsay is involved. So we are big on tailgating. Lana, so streaming or not? Yes, we're allowed to stream. Yes, I will be streaming. Everything is streamed. This trial is 100% public. This trial will be public. This is great news. And there is going to be none of this, so-and-so's testifying stays, so it's going to be sealed and shit like that. No, that's not happening. Oh, did Bev break for lunch? Oh my God, I get to have lunch. Be back going to the Idaho case. Yeah, back and forth. You guys, my house is set up like I don't even know, like I'm running surveillance over here. The only thing that's not being streamed is the voir dire, all the jury stuff. So I'll do that nightly. I will be there. I will get all the information. I will take the notes. And just like how I gave you a recap right there, I will tell you everything that's being asked, things like that. So be here during jury selection. I will be in Boise. I figured that's how it was going to roll, so I already plan to be there. So I'll be in Boise for the jury selection. Yeah. It's the, I think it kicks off like, I don't know, July 28th or July 29th or August 1st or something like that. So what else? So yeah, what I'll do is I'll probably go live. I might run a live stream throughout the day, and then because I'm going to have a bunch of helpers there with me. And so I think they're allowing us to be able to have our devices. And so I will then be using, God, I have to use fucking Twitter. but I'll give you like the full if you want to catch on the recap on the live show at night. So it'll probably be like they're going till 3:30, which would be that'd be 5:30 this time, 3:30 over there. And so I'll probably do my live shows at like 7, which would be 7 there, 9 here. That's probably a good time. You guys like that time? Yeah, that's what I'm leaning towards. What else? If you're local to the area, come on out. It's about justice. So this isn't about sides for me. It's if Bryan Kohberger is guilty, Bryan Kohberger is guilty. This is about a process, and as long as the process is fair and the evidence is put out, and if he's guilty, he's guilty, and if he's not, he's not. That's what I say. What else? Anything else? We still have a lot to cover, I think, here. So Hippler has a nice little rundown that we're going through. I think how I'm going to do it is I'll take pictures of my notes throughout the day, and then I'll use Hector. Well, I would be like live streaming throughout the day. And then if you want the recap for later, then you would just come back to that. But that I'd be able to then use the photos that I would take of my notes. But something like that. But yeah. Who's texting me? Oh, yes, Cash App. Thank you so much. Lorraine. Did I say that right? Lorraine, $20 for your road trip. Great work. I appreciate that. I think we got some more interesting news coming your way with some vehicles of interest. I'm curious if he's going to talk about the what crime scene photos, what different things will be shown. I mean, obviously they're not going to show some stuff. They're just not going to be showing some stuff. So I'm curious how he's going to handle that. So thank you guys for being here. What else? Remember, this is like the pre-trial conference, like update, status, hearing, and it's your way to voice some things here. I think Ann Taylor's letting Hippler run down what he has, and I think that at the end, when he's done, he's going to say, is there anything else? And that's going to be your opportunity if you're Ann Taylor, if you have any issues. Same thing with the state, if they have any issues that wasn't, covered. This is slated for a 3-month trial. Okay. So if it starts in the middle of August, you have September, October, and you're going into November, to the middle of November. So there's 300 witnesses. There's 300 witness lists right now. And this is slated from August 11th to like November 15th or something. For me, if Dylan and Bethany aren't shown on the video screen, as long as we get to hear them, I don't care. So damn. Yeah, what are you guys doing this fall? It's nothing but I mean, I'm over here thinking like, what's the state gonna show for? I think a lot of the time's gonna be spent by the defense. A good clock to keep would be like, who's on the clock more? I think the defense is going to be on the clock way more. Candace, yeah, she's having a baby right now. I reached out to Candace. I was getting so many emails about reaching out to her. So I love how he's not going to let law enforcement come in there and hide their faces. I absolutely love it. And it's rightfully so. You had a huge part in this investigation, okay? In everything that you said and you did. You're going to own it, okay? You're going to own it. I'm not going to hear some bullshit about, oh, undercover this or undercover that. Nope. Nope. Sorry. Not interested. So I think that's the right call. Own your work. Dude, the feds did everything in this case. You think Moscow, Idaho's local PD, what do you think they did? Nada. Not a damn thing. Payne's over here testifying that he's never run a fucking Apple warrant before. Hitler, you're messing my style up right now. I need to get my lunch. I'm gonna have to get a DoorDash. Yeah, I'll go with Chipotle. What are you guys having for lunch out there? All you lunchers out there, what should I get? I didn't eat breakfast. I have to eat lunch. Running on E. Somebody asked me how many hours I sleep a day. Hi. Let's see what's going on over here. Atlanta is deep in 14 or I-4. We're on our own. What do you guys need? What's up? What do we need? Music a little better. Music there. Oh, they want some music. I think Karen Reed's team is just crushing, just showing the corruption, showing the crap. Oh, Chipotle Burrito Bowl sounds fantastic right now, doesn't it? I think it does too. I really want like a regular taco. I want to go to a regular Mexican restaurant. Just want straight regular everything. Balance won't be allowed to testify off camera. He was allowed. Yeah, that ain't happening in this trial. It's because is she representing herself again? She should have put a motion in. Lana, is closed caption on this trial? What? Girl, you think that Judge Hippler has closed caption? He can barely run this damn website. Nick Balance, show me your face. What do we got going on over here? I want to get I got to get a Karen Reed update really quick. I want to know what Scorty Bello just unleashed. I don't know if they're going to be bringing up the leak. Refresh, it's back on.
Do you have time left? Who you would take and in what order?
What? Okay. Witnesses. Here we go.
I do like to use the time efficiently, so I don't generally grant the request if we're normally stopping at 3:30, at 3:10 or so to say, when you end a witness, well, can we just stop here? The answer is generally no. Let's use the 15, 20 minutes that we have, because in a 3-month trial, that adds up at the end of the day. So have enough witnesses ready to go to fill the time. And it's always good to have one or two who you always have at your site. So for example, if the state, a law enforcement officer, who's there, for example, you can call and put on something if worse comes to worse. But I want to make sure we use that time efficiently. With, in addition to giving the list of witnesses you're going to call, you need to provide a list of exhibits you intend to introduce with that witness, short of obviously impeachment, so that the other side can look at those. That doesn't include exhibits that you would put in as part of redirect examination. So for example, the defense in the state's case cross-examines on some other exhibits that you didn't bring up, or there are exhibits that you didn't bring up that would explain what the defense brought
That's
up.
ridiculous.
You don't have to give notice of those exhibits. You don't have to anticipate that, in other words. Now, this is not a remedy or a right that I'm likely is going to be resulting in exclusion of evidence. It is something that you're going to have to deal with me if you're not complying with it. And I will figure out something to make sure that you do, although I don't expect it will be a problem. You should know what exhibits you're going to use, and there's no real secret here about what exhibits go with what witnesses. And I say that because there's always going to be leeway where you have an exhibit that you forgot you need to use, or a witness testifies in a way that you now need to use another exhibit. So, there's leeway there, but giving the other side a general idea of the key exhibits that will be used so that they can review those to prepare, I think is fair. The corollary to my use all the time that we have is don't filibuster. I will give an example that I have used, that I have violated my own rule in the past. When I was in your shoes, where I had a young associate handling a witness who the next witness was going to be the client, and we didn't want to get to him that day. And he kept turning around thinking he was done. And I kept going like this, meaning fill up the time. Don't do that. Use the time efficiently, but don't filibuster. I've learned to come, as a judge, you sometimes feel like your client is the jury in some ways, right? You want to make sure that that they are comfortable. You want to make sure they are treated with respect, and make sure that things go as quickly as possible for them. And so I've come to respect that. And so I tend to want to make that happen as much as possible. So, don't waste their time, either by having gaps that we can't fill, or by filling it with stuff we don't need to use where we could be going to another witness. The lawyer handling a witness, if that is the lawyer handling on direct or the lawyer handling on cross, is the lawyer authorized to speak on the issues related to that witness's testimony at the time it is being offered? And so that is the only lawyer that's authorized to speak about that witness. So if there is a sidebar, only the lawyers handling the witness need approach, if it's specific to that. If it's more general and I need to talk to more of you, I'll let you know that. But I don't want the whole caravan up here for those discussions. Likewise, please do not stretch the shirt sleeve of the lawyer who is handling it by the other lawyer constantly pulling on their sleeve and writing a note and saying, don't say it, they'll get it. Just let them do their job. I'm assuming that there is, based on our prior motions, a agreement, well, I'm assuming at least one of you would like to exclude witnesses pursuant to 615. Because if that's the case, then they will be excluded, generally speaking.
It was the state's expectation that that's what would occur, and that's why we raised with the court earlier on the specific individuals that we've agreed could stay even if they haven't testified yet.
So 615 is one of those rules where if one side requests it, it's granted as a general matter. And so I'm assuming that we're going to be using 615 to exclude witnesses except those excluded by or excused from it by the court. Or you can agree not to use 615.
I want to talk about experts, though.
Right.
Experts being allowed to view other expert testimony.
Correct. Yeah, experts are generally excused from 615 because part of what they rely upon is the testimony of other experts. Part of what they rebut is the testimony of other experts. So experts generally are excluded. The parties, or in the state's case, a designated party representative, such as a lead investigator, is typically excused from it. I've already talked about the defendant's family in another ruling, and crime victims are excluded from it.
I want some further clarification with our experts.
And I
know
think
that
you guys agreed that your investigators would be excluded from it as well.
we did make that agreement. I think that may have even been in writing.
I'm sorry, I didn't mean to interrupt. I just had that thought. And I didn't want to lose it.
So that's okay. I know the court has talked before about the live streaming and being mindful that witnesses not watch the trial.
Ooh,
when they're
yes.
outside of the courtroom, just like they couldn't inside of the courtroom. What
Good.
I want to know is with experts who are allowed to be in the courtroom, can those that are far away watch the live stream version if they can't make it to Idaho?
Good question.
Mr. Thompson? Do you have any objection to that?
No, that seems to make sense, Your Honor. And I understood that the court was going to give an admonishment, acknowledgement from witnesses as they appear.
Bailiff, would you provide one of these to each side, please? This is an affidavit that each witness will have to sign.
Perfect.
And you hand to me as they are going to the stand when you're called by them.
Yes.
Specifically declaring that they have not watched the live stream. This is for witnesses who are excluded or otherwise consumed media about the testimony or evidence presented during the trial. It's not I'm not wed to the exact wording. So if you have wording suggestions, I certainly will listen to them, but that is the gist, is that they will provide such an affidavit each as they come to testify. Any concern with that?
Not with the wording at the moment. A question of clarification, though. If the case should reach a phase 2, does this admonition apply to those potential witnesses for phase 2?
So a witness who is only a phase 2 witness
Only a phase 2. Yeah.
and they attend phase 1. Is that what you're asking?
If they watch or attend any part of phase 1.
Well, the problem with that is that phase 1 is also part of the state's phase 2 evidence, as is the defense's, right?
And I think that would support the need for them to be able to know it if the state's going to rely on things that.
Are you talking about experts?
Experts and possibly lay people too.
Oh, explain to me why lay people should be excluded from it.
I don't think they should be excluded.
So you think they should not be permitted to watch the trial?
I think I've got some double negatives going on. I think that if we get to a phase 2, I don't think that those witnesses have to be excluded from paying attention to phase one. I think the protection for phase one is separate than phase two because of the rules of evidence that apply to any phase two, the lack of them that apply to phase two. And because the state's going to rely on what was in phase one. So yes, experts and some potential lay witnesses as well.
Mr. Thompson or whoever wants to address this.
Our initial inclination is to leave that to the court's discretion. I think the whole purpose is to avoid prospective witnesses altering their testimony in some fashion based on what they've seen going on in court. That's the danger. I don't know why phase two witnesses should be treated any differently than phase one witnesses.
Well, what I'm going to do is, I'll give you a chance to each submit something within 7 days in writing on that, and I'll look at it so that you can give me any authority that you might come across related to that issue. Give me a chance to think about it further, and for the two of you to perhaps talk to see if you can understand specifically who you might be thinking of to see if the state has a problem with that.
Nobody will be watching that trial if you're a witness and not excluded.
Counsel who calls a witness, unless it's clearly an adverse witness, in which case counsel needs to notify opposing counsel that they have not admonished that witness. But otherwise, counsel is responsible for ensuring witnesses are aware of orders in limine, otherwise clearly off a testimony that is off limits. Make sure they understand, the Rule 615 requirements and the fact that they're going to have to sign an affidavit subject to the penalties of perjury that they have not watched this stuff. So it's your responsibility to make sure that they're aware, because when they don't comply, I'm going to be asking, why did you make them aware?
I went with Chipotle, guys, for my lunch. How about you guys? What do you guys get for lunch?
While we were talking about the jury, I failed to give you the juror affirmation that will have to be signed by the jurors each day. Let me give you a copy of that along the same lines. So that is an affidavit each juror will fill out daily, indicating that they have not violated the court's instruction or otherwise been exposed to testimony or information about the case outside of the trial itself. If I exclude evidence and you need to make an offer of proof, the opportunity to do that generally is when the jury, when we're not working with the jury, such as the morning session or the afternoon session, so that you can make that record as best as possible. That can be done typically by simply making an oral reference to what the witness would have testified or what the evidence would have shown had it been admitted. Okay, let me, I think the rules are pretty clear, but some judges may have more leeway than others about objections. Let me explain to you what my expectations are regarding objections. So objections to questions or exhibits should be stated simply and without argument. It should not be a speaking objection. So for example, an objection, a proper objection might be, for example, objection hearsay. Objection foundation requires a little more. As you're probably aware, there's case law that is an insufficient objection. You have to identify what is missing from the foundation as part of your objection. If you think that doing so would put information in front of the jury that you're not certain I'm going to allow, please ask to approach. I tend to be a rather quick on rulings, on objections. I've been known to, testimony objection overruled, sustained immediately, without even giving you much of a chance to express your concern greater, because I can usually anticipate what the potential issue is and whether or not it's an issue. That said, if you think your ox has been gored and you need to address the issue more, either to have a record or in order to perhaps convince me that I'm maybe looking at it differently than what you anticipated or than I should, please just ask to approach, and then we can have a discussion here at the bench about that. If you need to make a further record for any reason on an objection or in response to an objection, simply ask to approach and we will have that discussion. I'm sure by the end of the trial, we'll have to replace the carpet from the trail leading from council to the bench, but that's fine.
There's our girl asked you with the crack of a
Shown you
smile.
before, the court reporter will have a device
Oh,
like
look at
this that will allow her to hear through her earphones what we're saying. There will be white noise that's played in the courtroom so the jury and others cannot hear what we're talking about. There will be a physical barrier that blocks most of the view of the jury from what we're talking about at the bench that's rolled out so that they can't see. And we can have fairly fulsome whispered discussions here at the bench about that, whatever the issue may be. I have found in, doing this for far longer than I care to remember, that when I send the jury away to hear argument on an objection, what might take 3 minutes to have the argument on takes 12 to 15 minutes to get the jury back again. And then we lose a lot of time throughout the day that way. And so my preference is, as much as possible, to have those discussions here at the bench. Now, if it's a very significant issue that requires much more leg room, so to speak, to talk about it, then I will chase them out of the room, but I prefer not to handle the more routine stuff. One of the things about, I've had counsel before who confuse the idea of the need to make a record with the need to get my ruling and then offer a rebuttal to it. That is not making a record. That is making a rebuttal. And at least until it goes over to State Street, I get the last word and not you. And so I don't generally afford that opportunity. So if after I rule and you tell me you need to make a record, it truly needs to be a record on something that for some reason you were unable to make when you had the opportunity to do so, and not simply to see what my ruling is and then try to pick it apart. I will reiterate what I started with is I don't like surprises. If you anticipate an objection or you anticipate objecting to testimony you certainly know is coming, let's talk it over before the witness hits the stand, before the jury's in the box, so that I have as much time as possible to be prepared so I can give you as best a ruling as I can. and so that you can make as best an argument as you can. If you anticipate the potential impeachment of a witness by prior testimony, whether that's grand jury testimony, whether that is transcribed in witness interviews,
Pain.
whatever it might be, please get that to me before the witness hits the stand, and preferably towards the start of the trial, so that I have that available, so I can have read it before the witness testifies, so that when you then ask to either impeach or to refresh recollection or whatever it might be, I will have read that testimony. Don't be mistaken in your belief that I have all that testimony. If it, for example, happened with Judge, I don't necessarily have all those transcripts, so get them to me. Or if I do, they're in one of 100 boxes somewhere back there.
Your Honor, if they've been supplied with exhibits and the purpose was just for that, will that be enough for the court, or should I have an extra transcript at the start of the day if I think I need it on paper?
So let me know as far as advancing possible, and I will have staff look for that. But otherwise, it's probably safest just to provide me an actual copy of it.
Thank you.
But while I'm thinking of it, because I'm in my mind envisioning the materials from grand jury that we have here, the state did file a motion to get back its exhibits for use at trial. I assume there's no objection to that.
No objections.
All right. Mr. Thompson, if you may make arrangements with staff here to get those while you're here, okay?
Yes, sir.
And I assume you have replacements you have or will get to me for those.
And actually,
Whoop, whoop.
we had a procedural question we were going to ask the clerk. I'll ask your honor.
Clerk probably knows better than I do, but I'll go ahead and try.
We can do one of two things. We can either get together a set of photographs or copies of the exhibits and exchange those for the exhibits, or take the exhibits, document them, and then give the clerk what we've documented. We're happy to do it either way.
Well, my only fear is that you take the exhibit and then I don't know what the record is of what it actually looked like. Not to suggest that you would be involved in any chicanery and switching something out, but just trying as best I can to preserve that record.
Understood. So we probably will not pick them
Okay.
up on this trip, but we will make arrangements to have that done certainly well before trial.
Very well.
Thank you, sir.
Speaking of chicanery, I'm not fond, and you folks know that by now, of making accusations against opposing counsel that are not well-founded and supported by specific actual evidence. I know that you can get along, but I also know that over the course of a trial, particularly a long one, tension rises. And so I remind you of that to be professional. Don't talk to each other directly when we're in court, right? When the session's going, everything goes through the court as you know, the protocol with courts generally is. Refer to each other by professionally, Ms. Taylor, Mr. Thompson, not by first name.
Oh my God,
Well,
what is going on?
And again, avoid making accusations that you don't have the tickets for, or the receipts for, I should say. And under no circumstances should you make such accusations in front of the jury.
Under no circumstances, do you hear me?
It's a long trial, so as much as I want you to be prepared,
Oh God, come on.
you may have a local witness and a witness who's flown in that needs to get out again at the end of the day. And so it may be that we need to stop one witness's testimony to get the other witness in, and then pick the other one up as long as there's no clear prejudice from that, I'm generally flexible in allowing that so that we can accommodate that. And I ask you to both be accommodating to each other in that regard. All right, any questions about witnesses' testimony?
Just one, it's kind of a takeoff of what the court just mentioned. We have at least one, maybe a couple law enforcement witnesses in particular who have testimony relevant to different stages of the case. And it's our intent, with the court's permission, to call them at different times instead of trying to figure out how to call them once and have them talk about what's going on at this stage of the case and then what may be happening next week with the case. Is that acceptable to the court?
Well, let's start with whether it's acceptable with Ms. Taylor.
Your Honor, I don't know that I have a strong objection or really any business in telling the state how to put on their case. That feels really cumbersome to me. I was hoping for leeway the other way when we would call a witness ourselves, but they're a state's witness. I'd hope to have a little leeway to do all of my examinations so they didn't have to come back. I would otherwise defer to the court.
Certainly, if you're somebody's on your witness list, if you want to go beyond the scope of direct as part of effectively your case in chief in advance, I don't have a problem with that. And so if it's going to save bringing another witness back, I don't have a problem with that. I don't have a
Wow,
problem
that helps Ann Taylor.
if it doesn't get too
Oh, wow.
cumbersome. If we're having a law enforcement talk about a broad area of one phase of the investigation at a time, that's probably okay. But, having them come up and narrate between every other witness is probably too much. Then the question becomes is how do we handle cross-examination? And basically I will defer to the defense on that or the other side on that to the extent that we allow, which is, do you want to cross-examine about the information they just presented now? Or do you want to wait until their last presentation and cross-examine about everything? And so that'll be up to you.
Your Honor, with that said, then I guess I'd request that the state let us know when they call a law enforcement that's for a limited purpose right now, but is coming back for another purpose.
Yeah, they need to let me know that as well.
Yes, Your Honor.
Oh, man. The state's showing their hand there a little bit. There's going to be a lot of narration.
You don't let them know that. And, well, either way, it's your responsibility to ensure that they're back at some point available to the defense so that they can cross-examine.
This is
Even
going to
if
be
you
the
decide, oh, I don't
best
need them
trial
anymore.
ever.
You better not send them on an airplane somewhere where they're unattainable, because the remedy may be to strike all of their testimony as a starting point.
We would anticipate asking court and counsel if this witness may be excused if we're finished with them. And then I would give Ms. Taylor or other counsel an opportunity to let us know whether they still need that person.
Okay. Likewise, when you look at each other's witness lists, talk with each other and then write it in, get it in writing so we have it as to whether or not, for example, Ms. Taylor will need subpoenas to witnesses you have on your list that they want to also call, or if the other way around, you need subpoenas for their witnesses, or whether they will essentially agree to make them available. Anything else with respect to witnesses before I move to exhibits?
Okay.
Okay. All right. So I did require a meet and confer for you to go over exhibits, and I got those, and I appreciate the start that you have on those. There are a number of exhibits where there's appears to be, I can't tell. So for example, there's an objection to, for example, relevance or hearsay. Part of what I wanted to know, though, to start is regardless of whether it's ultimately admissible for those reasons, is there an objection to authenticity? In other words, I want to make the trial go as quickly as possible, avoid the need to put on a bunch of witnesses simply to say, this is what this is, and they don't really have any substantive discussion about it. They're just authenticating a document that if we were to be honest, there's no dispute that it is what it is. And so I may have you go back and look at that and add another column to the list, which is objections to authenticity. Now, some of the stuff, key actual evidence items, whether that's DNA or whatever it might be, obviously the defense is entitled to put the state to its burden with respect to chain of custody and all that. So I don't expect that. But on some of the other stuff, certainly to the extent that we can agree that if there's no good faith basis to contest the authenticity, then let's try to do that for everyone's sake. In that vein, I know the state had to withdraw its request to have certain documents self-authenticated to go back and do more work. Where are we at on that?
Yes.
Ms. Jennings can speak to that. Your Honor.
Yes. There we go.
Your Honor, I believe that we've submitted all of the certificates of authentication for all the exhibits we plan to introduce that way.
Okay. And you submitted those to the defense to review? And Ms. Taylor, are you going to respond to those?
Your Honor, we did. We met with the state last week, I believe, or the week before, and we discussed some of those records. There were some issues with them. Ms. Jennings provided me with a thumb drive, and I don't know if those have corrections on them, but I'll continue to let the state know what we think, if we continue with an objection or if we're satisfied that the rule's been met.
Okay. If you could get with each other and then provide me I didn't study the exhibits that I got a day or two ago or the spreadsheet that closely, but make sure I'm aware specifically of which exhibits there is no objection to the self-authenticating or otherwise not an objection to authenticity. Doesn't sound like we're going to need a hearing on that, at least for the time being, though.
Not that I'm aware of now, but certainly we'll keep our eye on it. I can alert the court, and if we can squeeze it into June 18th, that's possible. Maybe we
Sure.
can start that at noon.
Okay.
Oh, he was loving that. There you go, Ann Taylor. Show him a little shoulder, baby. Yeah, maybe we can start that one at noon. I know you want to start at noon on June 18th. How about that? Look at
Then I would certainly caution, at least because the state goes first for now, I'll say the state, that, belts and suspenders are good ideas when it comes to trial. So I would have my people I need to authenticate things under subpoena just in case. Especially if they're out-of-state witnesses, because that's not something you can do overnight. So the methods of displaying evidence to the jury,
okay.
Generally there's three ways to do that. One is by putting it on the Elmo and projecting the physical document, whether it's a writing or something else. The other is if it's a writing or something else, using litigation software of some kind to project it through the computer. And the third is passing it through the jury. That last one is the one I want to avoid as much as possible because that just takes too much time. So try to use the other two approaches as much as possible. Now, there are going to be some physical objects that it may be important for the jury to see, and I get that. But in general, photographs, things that are in writing.
Dude, this thing is gonna crash.
So oftentimes, and hopefully that's what you're doing, there's an agreement in advance stipulation to admission of exhibits. I generally don't allow pre-admission because what I find is that I admit all these documents that then are never addressed during the course of the trial. And I don't want a bunch of exhibits to go back to the jury that they have no instructions on, that they've had no question and answer with a witness to explain what the relevance of those things are, so that they can just go back and use to justify whatever position they want to have from them. I think that's dangerous. And so the process, if there's a stipulated to exhibit, would be to, just as you normally would, identify it with the witness, or not even necessarily doing that. You know you're going to use exhibit 6. Witnesses on the stand, and just say, Your Honor, I'd like to go over exhibit 6 with the witness. I understand that the defense has no objection to this. Look at you. That's correct. All right, exhibit 6 is admitted, and then we go from there. On voluminous documents, if possible, try to avoid sending the whole thing back if there's only a small part of it that's relevant. If that's not possible, let's highlight the parts that are relevant and maybe even explain through the witness whether any of the rest of it is relevant, right? So that they know what to look at. In that same vein, if you have a voluminous exhibit and there are, say, 5 or 6 pages from it that are important, what I might suggest is the exhibit be, exhibit 47, and then you have 47A, 47B, 47C as marked exhibits. They go with 47, but they're separate exhibits so that the jury can keep those in mind, and we can keep track of those. It looks like from what I received, the state's using S- number for its exhibits and the defense is just using numbers. Is that accurate?
It is.
Hopefully that won't get too confusing for people. Where we can, what I also suggest is that the defense is going to use as part of its case the same exhibit that the state has used and admitted. Let's not admit another copy of the same thing. Let's just use, so I like to say, the parties don't own the exhibits once they're admitted, the court does. And so there's no proprietary interest there. So if you already have it admitted in the form, just use that exhibit. Okay. I think my staff explained to you that in terms of submitting exhibits to the court in advance, if you would provide 2 copies of the exhibits in notebooks, so 1 copy in one set of notebooks and 1 copy in the other set of notebooks, and try not to make the notebooks bigger than about 1.5 inches each, at least on the copy you give to me, because it's just too unwieldy to use a 6-inch binder up here, or if I need to take it home and read it overnight to do that. So try to keep it to about 1.5 inches per. And then for the actual exhibits that are going to be admitted, provide those first day of trial or whatever to the clerk in each exhibit in a manila folder with the exhibit number marked on the outside of the folder on the tab,
Oh my God.
with the sticker attached inside the exhibit, so that she'll have a box of the proposed exhibits, the originals, and you can ask for exhibit X or whatever, and she'll hand it to you to use. At least for the document exhibits and photograph exhibits. Physical object exhibits, work with the marshals on getting them in the courthouse. So for example, if it's something that's going to raise alarms at the security line, such as, I don't know, a knife, make sure you've got the aid of security in advance to get through that. The TCA can direct you to the marshal service and who to talk to there. We tend to use for dangerous items like guns and knives, a display box that the item would then be locked in to display to the jury. And so that can go to the jury without fear of an accident happening. I don't think there are any guns in this case, so I'm not as worried about that in terms of those being pointed at anyone by accident. But in terms of the knife, will probably be in a display case.
What is going on? This is wild.
If you're going to be using illustrative exhibits, give counsel notice of that as reasonably far in advance as possible for them to have a chance to look at those. Items for which chain of custody needs to be maintained until it's admitted. I'm going to leave that to the state to figure out where it's going to be stored and how it's going to be stored. Whether that's with a sister agency or whether you're going to have the sheriff up there bring down a trailer that can be locked up and kept at the sheriff's here property or something like that.
Oh my God, trailer? Love it.
That. For physical objects, also provide color photographs so that we can have those in the record. At the end of the trial, we will likely give back physical objects to law enforcement to maintain. Depending on what it is, we'll see, and depending on what the outcome of the case is. But it's nice to have those color copies available for the record. Triple check all of your exhibits, particularly documents, audio and video, to ensure that there's nothing on there that is not supposed to be on there. Give audio and video to counsel far enough in advance they have the opportunity to determine whether they have an objection to anything in there, and you have the opportunity to either make redactions in accordance with the objection or to get a ruling from me about those redactions. What I don't want is the jury to be sitting in the back room while you all are making redactions at the last minute during the middle of trial.
Yes.
All right, for closings, kind of the same idea. I'll ask in advance for a time estimate, and then if it's reasonable, agree to it, but then hold you to it. A little bit more liberal, obviously on closing than in opening. If you're going to display things in closing, kind of the same light rule goes, which is lights on or lights off, so you'll have to choose. You can move about the well, but don't get in the juror's personal space.
Get back, bitch.
The state, when it gives me a time, I will keep track of that, and then for rebuttal, it'll be whatever you didn't use. So when you're giving me estimates, include your rebuttal in that. If you would like time reminders from the court throughout it, for example, if you're planning to keep 20 minutes for rebuttal, you can ask for a heads up at 30 minutes, something like that, when you have 30 minutes left, so just let me know in advance. All right, questions either about closings or about exhibits?
Your Honor, as to the defense exhibits, it would be helpful if they could be separated or at least delineated between which is for the penalty phase and the guilt phase. As the court will see when it looks at our spreadsheet of our responses to the defense exhibits. Some of them, we could see we wouldn't object to them in penalty phase, but we would in guilt phase, and they aren't clearly delineated at this point. If that's something that we could have addressed sooner than not, that would be very helpful.
Any problem with that, Ms. Taylor?
No problem. We did go over that when we met last week, and I identified which ones were for a phase 2 if we get there. I don't have a problem stating so, but we did make them aware.
Okay, well, maybe if you can just put it in writing so that they have it, that'd be helpful. That way we don't have any misunderstanding between the two of you. Thank you. All right, once you get and revise your spreadsheets based upon what we've talked about today, I'll start about part of what I'm going to do with the time that we have between now and trial is start going through all those, looking at what your objections are, getting my preliminary thoughts together on that. And then we may have another hearing just to kind of go over some of that if I have stuff that I think I can rule on in advance for you, or if I have questions, et cetera, but I'll let you know. All right, anything else before I move on to jury instructions?
Not from us, Your Honor. Thank you.
As far as objections, Your Honor, the court has issued a number of decisions on motions and limine motions to dismiss. From the defendant's trial brief, the defendant indicates that he plans to raise those same objections again at trial. And it strikes the state that if that's going to happen, to preserve the record for no other reason, that should be done outside the presence of the jury, as opposed to interrupting testimony and presentation of evidence on matters that have already been ruled on by the court.
Ooh,
If that is acceptable to the court and counsel.
interesting.
So there's not a need to object again if I've already ruled on the objection. If you're asking me to reconsider, yeah, I think that's something you need to take up outside the presence of the jury, if that makes sense.
That does make sense. And on situations that may arise where we might want the court to reconsider, we'll definitely take that up outside the presence of the jury. I do want to make sure that things such as the model house that was the subject of a lot of objection, that there's a noted ongoing objection to it. I don't mind anticipating that and bringing that up before trial starts and outside the presence of the jury.
And to be fair, you know, I only have what was proffered, right? And so I had a general proffer that the testimony will be that it, as I understand it, that it is consistent with the general layout, but not to scale, and that it would be helpful for the testimony. I don't have a problem with an objection based upon what that proffer is actually at the time. And so I think that's fine. I don't think that there's a need for an ongoing objection once that's done, but
And we can have a standing objection.
that helps.
Yes, sir. Thank you.
And Taylor's going to be bringing it.
Jury instructions I provided to you, I think yesterday, maybe pre-proof instructions. Did you get those?
I did not receive those.
Have we not sent those out? All right, I'll send those out probably today or Monday. They're not particularly, I think, controversial. They're pretty stock. On the pre-proof, in a capital case, there's a instruction. Normally what we instruct the jury is don't concern yourself with punishment, the subject of punishment. In a capital case, we are supposed to instruct them under 700B of the capital instructions in the pre-proof phase that it is a capital case, which obviously they're going to know through jury selection. So there's that instruction in there. And what I've done is we're also supposed to instruct them with 700C, which is this is a capital case and you'll have to decide if you find the defendant guilty, what penalty to impose. But then 700C says, instruct them in a separate instruction, don't concern yourself with the subject of penalty or punishment in the guilt phase. I've combined those two things together, so take a look at that. I think it reads better than trying to do two separate, potentially contradictory instructions. I think it does it in a way that makes it more understandable. Other than that, they're very stock instructions. If there are other instructions that the parties want to be included in the pre-approved, for example, any stipulations that they want me to advise the jury of, let me know by submitting a request and copying my law clerk on that as well. I think you'll probably get before too long a set of post-proof instructions that are very loose in the sense that obviously I can't anticipate everything. It is based on what I sort of understand now. But it's helpful to have a discussion about that as early as possible so that we're all singing from the same hymnal in terms of what the likely instructions are going to be. And, for better or worse, as you know, the Supreme Court in last year, 2024, revised all their capital instructions. And so in light of that, I will be as much as possible sticking with what they have provided, given that it's clear they've obviously given it recent thought. And so I think that best insulates the case from perceived error by the court is by using instructions they've recently given us. My plan would be if there is a guilty verdict on the any of the counts of murder, would begin the penalty phase as soon thereafter as we can. Certainly probably the next day, unless it's, Friday morning when we get that, then we may not start till Monday or something. But given that the jury will certainly be sequestered during that process, the plan would be to go forward. I also will use as much time as I've told you throughout the day to get that accomplished as we can. If that happens and we are in a penalty phase and there is a finding of aggravating circumstances, or then the court's discretion about which penalty to impose is pretty limited in terms of my discretion. In fact, i.e. none. It's either life without parole or death, right? In that case, I just want to get, before we get to that, defense's position on sentencing for the burglary charge, if they have concerns about sentencing at that time as well, given that it's probably not even a tail wag on the dog, let alone wagging the dog. So, but I'm not going to make you tell me that now, but I will ask you before the jury goes out what you want to do. I'm going to hand you another piece of paper that I would like to get back from the defense sometime in late June or early July, which is a declaration of last best offer. In other words, identifying whether the defendant received an offer and whether he has accepted, rejected, et cetera, just so that for purposes of post-conviction, we've documented that. Okay. Let the court reporter know whether you're going to want routinely daily transcripts or not. You don't have to tell her now, but
Daily versus real time.
so there's two options. You can have none, both, or all, or either. One is I think we can set up real time where you get real time at your table for whatever the charge is from the court reporter for that. Also, there's the potential to get transcripts each day. I don't think those things are mutually exclusive. In other words, you could order both.
There's separate fees if I want both.
Correct.
Yeah, make that decision.
Yes, not now. You may make that as we get close. And just contact the TCA and she will talk with the court reporters that will be assigned to this to make sure you understand what their structure is, or fee structure.
Why does Ann care about the fee structure? She should have unlimited funds.
And we obviously need to know, particularly about the real time in advance so that we have the technology set up for it. And it may require you to bring some of your own technology in the form of a tablet or a laptop on which it's displayed, right? Because we don't supply the hardware, just the software and the actual reporting. Okay. My plan today, as we sit, is to get through the jury selection. I see where we're at with the intent that we not sequester to start. As I explained this morning, the more people talk to the media and the more things that are in the media that are not admissible, whether true or not, the more difficult it makes things. And so I'm going to have to figure that out as we get close. For now, intent is not to do that, but we will have plans in place to revert to that if we have to at any point during the trial. Do either of you want to make a record about sequestration at this point?
Make your record, Ann.
I would say the only record right now is that we understand what the court is saying during jury selection. If we still don't know if that could come up, the potential jurors should just be aware that it could come up prior.
It'll be part of the question that the questionnaire, as well as part of the hardship determination is there some reason they would be unable? I get that they wouldn't like to be, but would there be unable? Do they have a sick family member they care for or whatever, where they have to be home, right? So we'll talk to them about that. Anything from you, Counsel Thompson, about that?
Not at this point. I understand the court might entertain some things in a closed environment later today, and we do have some sensitive issues to raise at that point.
Okay. That's my list of things.
Oh.
Did I miss anything, Giovanna, that you?
Right there. There was.
That's my list of stuff. And I know this has been a very sort of nuts and bolts kind of lawyer discussion today, but that's generally the nature of pretrials when there aren't contested motions to discuss. And so that's my list. I'm happy to answer any questions about my preferences or how I handle things that I haven't talked about, or address anything else that you want to talk about. I know we do need to go to a closed session at some point to talk about what will be asked of the jury specifically. I need to avoid that getting out to potential jurors. So we'll do that in the closed session. But anything else in the public session we need to talk about?
I don't believe so, Your Honor. Thank you.
Your Honor, thank you.
Okay. Let me just look at my notes real quick before I dismiss the public, and we probably take a lunch break and then come back and take that up. I do have a copy. I told you there's a new administrative order. I'll give you a copy of that just so you don't have to go dig for that. What's that? You've already given it to him? All right, perfect. Thank you.
Fair prayer that we could have, Your Honor. That-
Sure.
Oh, it's already at hand. Thank you.
Actually, I have copies of the preliminary instructions for you.
Oh, thank you, sir.
They've had lots of discussions off in the closed area.
In the closed session this morning, I indicated to you I'm going to be entering an order requiring retention of records by the state, and I'm going to write another one extending that to the defense as it relates to violations of the non-dissemination order. I'm going to give you a copy of what the order is going to look like that I will execute likely over the lunch hour.
There it is.
It does require some action on your part, counsel. And as I indicated,
It
I
was
would be
brought up.
open to a request for a appointment of a special prosecutor. And that special prosecutor to ask for a magistrate inquiry, so they have the power of subpoena and the power to question witnesses under oath, as well as the power to grant immunity. So I will be looking for that from you. And that one just deals with the state. I will get you one that deals with your side to preserve records, all right? All right. Anything else?
Boom, bitch, sit down. Yeah.
Thank you. Why don't we come back in about an hour, all right?
And Taylor took it to him. There you go. Boom. Y'all thought Ann was soft. Y'all thought Ann was soft. Ann Taylor plowing during the closed hearing. Literally, Dateline. Y'all are dumbasses. Okay? People doing interviews. They have no business doing interviews and saying the stuff that they've been saying. Did you just hear what's about to happen? The state has to get to the bottom of the leak. That's right. Okay. Yeah. That's why I never played that fucking 911 call on my channel. I refuse to play that 911 call on my channel. This is not a free-for-all. This is not a free-for-all. And it's being treated like a free-for-all. And fuck yes. 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 Go to town, baby. Woo! Love it. Fuck yeah, slay these bitches. Boom. For the love of money. Selling your souls and shit. Well, Lana, you cover the case. Yeah, but I don't fucking do it. I do it with integrity. But Lana, you do stuff for clicks and views. Well, no, I put out good material and I expect to have clicks and views because of the research that I put into things. Absolutely. Why would I cover, if I'm not getting people to view my stuff, that means I'm not doing a good job as a reporter, an investigative journalist. So what has gone on in this case is it shouldn't have been going down. And there's a special prosecutor to handle this. And it's going to come out. Simmer down, Tina. Tina is ready. Tina is like, okay, and they want to talk about getting immunity. Yeah, interesting. Get immunity. Oh, good. Come on over, Shannon. All right. The rest of it, I believe it's going to be closed. I'll run this for the time being. but I believe it is going to be closed. This is Boom Central. It was talked about at the beginning. It's going to be talked about again. They got some problems and they got to take care of it. People might need some immunity to cuff up some stuff. We're talking about Dateline says they have her client's phone. Where would you get an extraction that you have pictures and now you have Dateline who's potentially going to try to say that I just made that stuff up? Shit's going down in Boise. Shake it, baby. I love it. You can ring my bell, baby. You can ring my bell. Get them. Get them. Ring-a-ling-a-ling. You know it. I was like, you guys, shit's going down. Yeah. Do you see the way, I don't know. I see Hipper being a little nicer to Ann Taylor. You guys, the law enforcement is the leak. Law enforcement gave Steve everything. I get it though. You want to give stuff to a dad, a morning dad. I get that. Okay. But, I believe, just go listen to my material. Go listen back to my material. Okay. You can't just go running around saying all this stuff. Half of it's not even true. I mean, I told you, Dateline put a hit piece out. Why in the world would you put a hit piece out? Why would you put a hit piece out? This case has been handled or try to be handled the right way from jump, right? If you need to go try to put a hit piece out right before jury selection, that tells me everything I need to know about how strong anybody's case is. Okay. That was a push for the jury. That was a push for the community. It was absolutely ridiculous. And I have no idea if what they put out there is true or false, but I'll tell you what I think about Dateline now. Dateline was my last resort, like fuck 48 hours. Dateline, you just sold your soul. Like, yeah. Ridiculous. And Shane Bishop, the same guy who's been in cahoots with Jennifer Drake. Jennifer Drake and Shane Bishop. Shane Bishop is who produced and directed that episode of Dateline. Him and Jennifer Drake are besties. So you are who you keep your friend. You know, you are who you hang with, and so that's all I got to say about that. We are on a court break, and we'll see what happens. But I think the rest of it's going to be closed. But definitely, stuff is popping. Stuff is popping. Stick around. We'll see if they go back to any public session here. If not, then I'll end the stream, and I'll be live later. Hello, everybody. We're trying to find out here. We'll know here in a minute if we're going to be coming back online or if he's going to make it closed the rest of the way. So hang tight. I think the rest of it is private, but hang tight. Okay. Yep, we will be able to live stream the trial. I saw a couple of those questions in chat. Want everybody to know that live streaming the trial, yes. So that's a go. Anne revealed her third-party culprits. It's sealed right now. They have to add to it. She has to have it in by the 23rd of May. And then the state has until June 6th, and there'll be a hearing on it June 18th. And throughout some pretty heavy allegations And I think the rest of it's offline. I've never wanted to tailgate harder in my life than for this trial. Tailgating for the truth. Biggest bombshell drop. We have a special prosecutor who has taken over investigating and bringing charges upon the Dateline leak into Bryan Kohberger's phone and Google. There's immunity being offered. Ann Taylor went ham. There's chain of custody issues right now that I believe Ann Taylor brought up because remember, Bryan Kohberger's phone was in Pennsylvania. And if you go look at the search warrants and you go listen to Mallory's testimony, there was an issue with Brian's phone and it was like it was missing almost. But they're like, no, the FBI actually had it. And Mallory didn't understand how they even got it back. So there's chain of custody issues right now. And the Dateline leak from the phone is absolutely like it goes hand in hand with the chain of custody issues. So, yeah, we'll see. But there's a special prosecutor assigned to the case, and they're not going to give up. I mean, they got some issues. I noticed a different tone with Hippler and to Ann Taylor. I can tell you that right now. So, thank you there, Lisa. Thanks, Lana, for your hard work, and everyone else. You all rock for our rights. Absolutely. You know, Bryan Kohberger may be the guy, right? But at the end of the day, it's innocent until proven guilty. And in front of our eyes with the Karen Reed case, with Delphi, now here, Idaho4, there was a lot of fuckerage going around. And that stuff just can't happen. Then you got people doing interviews saying that they're just going to unleash and put everything out there. And it's like, wait, what do you mean to put everything out there? What do you have? What do people have when this case was being, so close to the vest and blah, blah. So it's going to come down to who's the leak. Was it the state police? Was it the local police? Or was it the FBI? Dateline doesn't end up with extractions for nothing. Those photos and stuff, those came from extractions from a phone. And the phone being Bryan Kohberger's. Mark B's in chat. What's up, baby? All the mods. We'll try it again here in a second. All right, I got official word. It's over. There's no more public part. So I'll be live later. Hit me up. Thank you so much. Appreciate y'all. Bombshells. A special prosecutor assigned to the Dateline leaks and more. Love it. Friggin' love it. All right, guys, cheers to yourselves. See you back here later. Good night, good afternoon, wherever you are at. Peace out. Join me over there on the Karen Reed case. I've been running 2 streams, so. All right. Is that right?